persons having anything to do before the Honorable the Justice of the Appeals Court, now sitting in Boston, far within the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated. Good morning, Your Honors.
Morning.
Good morning and welcome to the Appeals Court. I'm Justice Peter Sachs. To my right is Justice Rachel Hershfang. To my left, Justice Gloria Tan will be your panel for all 6 cases today. If you've been to the Appeals Court, you know you've got 15 minutes. There's no rebuttal time. When the light turns green, you can go. When the light turns yellow, you've got 90 seconds. And when it's red, you can finish your sentence. We have read the briefs, we have read the record, we understand the procedural and factual background of your cases. So 15 minutes goes quickly. I would encourage you to get right to the heart of your argument. And with that, I will call the first case, which is, I'm not sure this is the right one. Pachico, okay. 24P665, Commonwealth versus Pachico.
Thank you. Good morning, Your Honors. May it please the Court, Stephen Nato on behalf of the Commonwealth. This is the Commonwealth's appeal from an order of dismissal for the Commonwealth's failure to preserve evidence. And as the brief argues, the judge's decision on that basis was plagued with critical errors of both law and fact. Most significantly, the error of law, which is, so as you know the facts, this case involves a Snapchat image of the defendant's penis sent to a 13 or 14-year-old student in his dance class. It was sent via Snapchat, at which those images disappear after 24 hours. There's also something called metadata that's not referenced in the defendant's motion, but the judge did bring up himself. So the record doesn't have any information on that, but I did find a federal court case that's cited in the brief as well. That information is only saved for 31 days, something like that.
And metadata doesn't include the images, right?
No.
Isn't that just the back and forth?
Right. That's my understanding. I know when they got the metadata, the police in this case were able to get some of the information about what the messages were, but not all of them. And so I'm not sure what the distinction is there. But the image and the Snapchat information were never in the Commonwealth's control. And the failure to preserve issue deals with evidence that we've had and lost or used up in testing and those sorts of things. We didn't lose this when it was reported to the victim's mother. She went directly to the police. That was more than 30 days after this had happened. I think she reported to the police on December 31st. The image was allegedly sent sometime in November. And Richardson is the first of a string of cases cited there that stand for the proposition that we have no duty to go out and chase down any particular kinds of evidence. The remedy for our failure to conduct a thorough investigation is a Bowden defense, not a dismissal. As I mentioned, the cases the defendant cites in support of his contention that failure to preserve is the right frame all deal with that situation. None of them deal with the case we have here, where it was never in the Commonwealth's control. We did our diligent best to get it when we did hear the allegations. I believe 3 subpoenas were sent to Snapchat. The victim's iPad was searched, and the defendant's phone was the subject of a search warrant as well. So part of the judge's basis for dismissing or granting the motion to dismiss was he felt the Commonwealth was negligent to some extent, but I think the timeline here supports the fact that we did everything we reasonably could do. I'm not aware of anything else there is to be done in those circumstances.
Can you address the probable cause issue? I assume you agree that if we disagreed with the judge on the preservation issue, we could still affirm if we thought there was no probable cause.
Sorry, did you say probable cause?
Yes.
Or no probable cause? So I think this is a little sort of a procedurally interesting wrinkle in this case where there were both the De Benedetto motion and the motion under appeal here. The judge considered the probable cause issue and denied that motion allowed on this basis. So where...
Right, but the defense not seeking any more favorable result than he already got. He's just seeking to affirm an order of dismissal, potentially on alternate grounds that were raised and litigated below.
Yeah, so normally I know that the court has the power to do that if it's, laid out, and maybe we have the police report.
So is there probable cause here, and what makes this, we're supposed to do an independent review of whatever evidence there is to make sure that we're not, that the prosecution doesn't infringe on free speech rights?
So there are a number of cases that deal with First Amendment issues when an image that's disseminated to a minor is missing from the trial. You have those cases like Militello and Rex that deal with images from different publications.
It seems like we can do the review based on the evidence that will be offered.
Right, yes.
Whether it's the photo or whether it's testimony about
Yes.
the photo.
So you can do it when it's missing, and here, rather than obviously as part of some publication, the defendant sent a picture of his own penis to the student as part of a larger inappropriate conversation. I cite Minkowski. I think it's the Commonwealth's best case on that particular issue, where it's a similar thing. I think it was a video maybe in that case sent to this girl, young girl, and then he uses that as part of the currency to say, you have to send it back to me, which is basically the same thing that happened here. There's also broader context in the lead up to the photo.
Context. Can we consider context in deciding whether this would appeal predominantly to prurient interests, or are we limited to the matter itself, the harmful matter, meaning the...
Well, I think Minkowski stands for the premise that you can consider at least some context. I don't know how far afield from the image itself.
Well, what about Militello? We consider the testimony regarding the photos only, and not as they may have been viewed in conjunction with certain lewd comments made by the defendant as the victims were observing the pictures.
Well, the defendant in Militello did not create the image. It was not an image of himself. Again, I think that was the Playboy or the whatever magazine. And so it's from a publication. He has nothing to do with the image itself.
Why does that matter?
I think it speaks to how the image was created. Again, part of a sort of mass-marketed publication that obviously the First Amendment.
Is that a relevant factor, though, whether he created the image or not?
Not necessarily, not necessarily. So, the First Amendment protected the defendant in Militello from a conviction for disseminating that image to children, even though obviously he didn't create it. But I think the context was different, where this image in both Minkowski and in the instant case, the defendant created the image specifically for use in this kind of cycle of abuse with a young child. And I forget which case exactly it says this, but it's...
Allure, it's a federal case, I think.
The
First Circuit case, suggesting that image was created as a lure to the child to...
That too, but I was thinking of the interest in the state in protecting children from, sexual predation warrants some infringement on the First Amendment, right? And so...
But we've still got to look at the image or what we know about the image to determine if there's probable cause to think that it would predominantly, to appeal predominantly to the prurient interest of minors. So what is it in the police report, in the description of the image, that suggests it would appeal, creates probable cause?
So I think because he sends the image in sort of that, here's me, now you send me one of you, it is inherently part of that prurient relationship, inappropriate relationship in a way that other images may not be. And there's no evidence that this was sort of like a modeling shoot or a burlesque shoot. He just kind of took the picture of himself, colloquially called a dick pic, pardon my language, but makes no serious pretensions towards literary or artistic
Well, that's
value.
a separate prong of the statute.
Yes.
so to speak.
Yes. The image itself, A photo of a man walking nude on a beach.
In and of itself, that I think would be protected by the First Amendment, and depending on, I think circumstances do matter, and I think the cases stand for that point. It is, pardon me, Commonwealth versus Newby that talks about, that not only the description of the image, but the defendant's statements about it show his own awareness that there was no value to this. It was an inappropriate image, harmful to a minor that he sent to them, that, he clearly was aware of that as well. So he didn't think he was engaging in protected speech, I guess is one answer to that. But I think under the sort of cases of Minkowski and some Newby, and it was Bean, that conduct is appropriately prohibited in light of the compelling state interest in protecting children from exploitation, even though the prohibition incidentally impinges on First Amendment freedoms. I think within those three cases, this one falls pretty squarely along those lines, Minkowski being the most direct comparison.
And which case is it you think that is the best for you in terms of us being allowed to look at the context as well as just the description of the image itself?
I think Minkowski hits that, where they say the defendant used the video as part of the currency of his sexual and emotional abuse of the victim. For example, he presented it as one of the reasons that the victim had to send him a photograph of her own genitalia. And then Abdullah is the one. These factors certainly enhance the reasonableness of deeming the photo harmful.
And when Minkowski said the defendant used the image as currency, was that in the course of applying the part of the test that refers to appealing predominantly to prurient interests of minors?
I believe so. I'm not precisely sure, but under the
In the police report, it notes that at least the initial disclosure by the minor to his mother mentions two photographs, the photograph of the penis, and this is page 11 of the record appendix, another of his buttocks with the caption, "better than ice cream." Was that photograph also part of the discussion? I didn't see that in the motion practice below.
I don't think so, or among the parties at the hearing, but I think it is at least arguably relevant as part of that, again, that whole overall context of what these messages are all about. I know there was some testimony too about a pornographic image that was sent that may present the Militello problem, which is obviously falls under the First Amendment. But again, here it is the defendant's own picture of his own genitalia that he took himself and sent to a child. No adult in the Commonwealth would think that was appropriate.
Can I ask you about this standard of review, which I don't think you addressed in your brief? Do you agree with the defendant that we're reviewing for abuse of discretion or error of law?
I apologize. I didn't clearly look at that directly. I overlooked that one. I think it would be de novo. It's on the papers. The court is in as good a position as the motion judge was. But even under an abuse of discretion standard, I think it clearly is an abuse of discretion to apply the wrong legal framework in dismissing a case that the law doesn't apply to there. And then again, as to Justice Sachs's question, for the reasons I've mentioned, I don't think probable cause provides an acceptable alternate basis to dismiss the case. Obviously, our position is the dismissal should be vacated and the case should be returned to the trial court. If there are no other questions, I will leave it there. Thank you.
All right. Thank you. We'll hear from Mr. Howard for the defendant.
So on behalf of Mr. Pachico, I'm asking you to affirm the judge's decision on 2 grounds, and of course for failure to preserve that image that was allegedly sent to the alleged victim, as well as on the probable cause grounds that although the judge didn't adopt, were clearly presented to him and supported by the record. So I am asking for 2 bites at the apple.
So what would you have the government do to preserve the image? Because the whole sort of premise of Snapchat and these images, right, unless they're screenshot, my understanding, right, is that they disappear.
So we're told it disappears, but there's actually no support in the record that it disappears, right? We're dealing with the police report at the time at the motion to dismiss for failure to preserve. One of the issues was what evidence, and the Commonwealth didn't present a witness, and the judge said, well, here's your opportunity to present your witnesses to develop the record. We're on for hearing, and they didn't have it. So although there's a case that might say 31 days that ADA NATO cited relative from the Federal Circuit, that it will disappear within 31 days, we don't actually have that specifically from any Snapchat custodian. Moreover, to address your question specifically, what should they have done? Similar to Harwood, I would suggest that on December 31st, when mom reports that John has received an image, they've got the defendant's name, they've got the image. 2 days later, mom responds and says it was communicated by Snapchat. Harwood, it was the Insurance Federal Board file. There was no evidence in Harwood that they sent that preservation letter. The police have a report on December 31st, followed up on January 2nd, no evidence of a preservation letter going to Snapchat to hold it because they don't apply for the search warrant until
4 days later.
4 days
right,
later.
On January 6th.
So in terms of negligence, because Harwood is, hey, the insurance folks had it, it was, the casualty claim, they lost it, don't blame us, we didn't have it. And the appeals SJC said, well, yeah, but there was no evidence that you took affirmative steps, understanding the importance of it to seek to preserve it. So that's my strongest claim, Judge, that I understand that the police didn't have it, but in Commonwealth v. Sassville, they didn't have the evidence, the unborn.
Well, someone had it, though, right?
Yes, someone had it.
That's the difference, I think, in the cases that you cite, Sassville and Neville, right? That's the difference, I think. Aren't those cases distinguishable from this case? Because in Sassville and Neville, the third party actually was in possession of the evidence in question.
Yep. I push back on the premise. We're presuming that Snapchat didn't have it on December 31st or January 2nd when the mom is reporting defendant, it's by Snapchat, and there's a 4-day delay where the officer, I've seen preservation orders every day to hospitals, to clinics, you name it. There's no preservation. The officer, whether it's Officer Borden or the detective, doesn't take that step to seek to preserve it. We're being told they don't have it, but we don't have any evidence that they didn't have it, and they didn't.
Well, who's the they? Who's they who don't have it?
Snapchat. We're being told that Snapchat doesn't keep it.
Okay, so
But-
in your view, the Commonwealth can't bring a case if it fails within 4 days to go out to a third party looking for evidence.
I am saying that where the police have the information that potentially exculpatory evidence is available, they know the kind of evidence and they know where it's located.
How is it potentially exculpatory?
Because the whole premise of the allegation is this image. And without the image, the defendant is denied 2 potentialities to refute. Recall, this is, it's the dissemination of the matter. It's not enticement, it's not lewd lascivious, it's the matter which has to be understood objectively. The defendant is deprived the very evidence that is supporting his charge to present to your honors to say, this is what accusing person says, but look at the image. It doesn't, directly, doesn't predominantly is this a natural image? And he doesn't have that to have affirmative evidence to negate the allegation to establish his innocence. Moreover, in this case, how it exculpates him too, recall John complaining, pseudonym. John says, reports to mom. No one sees the image but for John, right? There's there's a Jew.
That could be sufficient.
Excuse me?
You agree that that could be sufficient evidence at trial, that the testimony about what the image contained?
I agree with the premise that the Commonwealth can proceed with testimony of what the image contains. I respectfully reject the contention that what was described in this police report is matter harmful to...
But that's for the jury.
So you accept the premise that testimony about an image alone, not with regard to the facts of this case, could be sufficient to establish the elements of harmful to a minor?
I've seen it. I saw the Ferrari versus Commonwealth case. I understand the proposition that the young woman in Ferrari was, they didn't keep the videotapes, but specific graphic description of what was contained in the videotapes, including sexual contact, sexual conduct. Those were specifically described, graphically detailed. It is for the jury for sure, but also under Commonwealth v. Rex, once the indictment is issued, the defendant has the opportunity under the First Amendment to present the image or to challenge the description of the image to the judiciary for a separate.
The difference, I mean, I think it was the Rex case that said our task is no different. Yeah, the nature of the assessment by an appellate court does not change based on whether it occurs after indictments are handed down or after trial.
Right.
That may be true where there's an image, but where the Commonwealth is relying on testimony about what's in the image, the probable cause inquiry is quite different than what the evidence might be at trial. Would you agree with that?
The testimony at trial may differ from what the evidence is, what the description is contained in the police report. But when we're in the district court and we're proceeding by way of Di Benedetto and we're relying on the four corners of the police report presented to the clerk magistrate, which serves the basis of the complaint, under Di Benedetto, I don't mean stuck, but we are left with what is reported in the police report.
But my question is, the inquiry here is whether there's probable cause to believe, and that's based on the description of the image. That's not the same as looking at the image itself, which in Rex could be done just as well in advance of trial as it could after trial. We have a different situation here.
We definitely have a different situation, but it doesn't preclude the inquiry. And under the and with respect...
But it's a different inquiry because, as you say, the victim can testify, and maybe he remembers more, maybe he remembers less. But the issue for us is whether there's probable cause to believe this could appeal to predominantly to minors' prurient interest.
As contained within the body of the police report without the image for review, which I suggest gives greater circumspection of the court's consideration of whether or not the First Amendment is being violated in this.
So does it matter that this image is not just a nude photo, at least according to the description in the police report? It's not just a nude photo, but it's the defendant lying on the bed in low light with his penis lying on his stomach, smiling at the camera. Does that make a difference to whether it appeals to minors' prurient interest?
Yes, that's the consideration, Judge, is whether or not that description gives rise to this idea that it is appealing to our interests in sexuality, etc.
Could a prudent person find probable cause to believe that the defendant was displaying his penis?
No, Judge, not based on the recitation contained within the body of that police report. Recall Militello, and I understand it's the Playboy magazine, but the images, one of them, it's specifically noted, one of the young boys in Militello describes the image of a naked woman lying in bed. What we have in this case is a naked man lying in bed, lying in bed in the dark. We are not told, and not to get into the, but we are not told that we're not having a semi-erect penis, not having it predominantly displayed.
It's on his stomach.
Excuse me?
It's on his stomach. The penis is on his stomach.
Okay.
Could a prudent person think that that's not an ordinary position for a penis and that it's being displayed there?
Judge, lying down.
No, it's difficult to talk about.
No, I'll get to it, but I mean, I guess the suggestion that he was erect, I mean, we don't know.
I'm not suggesting it was erect. I'm suggesting that it was, a person could believe it was arranged there.
I would, with respect, I think that would be speculation. We have the description is a man lying in bed in the dark, hands aren't on the air.
Could be very innocent.
Exactly, Judge, and under the First Amendment, we need some, Ferrari, when there was no image, no preservation of it. This isn't a specific description in graphic detail of what the gentleman is doing. We are told that it's not uncommon to lie in bed nude. And this isn't about appropriate or inappropriate, I get it. But in terms of the objective analysis, whether this is matter that is harmful to minors as defined, it's certainly not obscene because there's no allegation of sexual activity, masturbation, fondling, touching another person's anatomy. This is just a single solitary image of a male person nude in bed.
So if the photo were of a woman, and the woman had her legs spread wide apart, so that her genitals were clearly exposed to the camera.
Predominantly displayed, it likely would be if as what she's predominantly displaying the genitalia. Description in our case, there's no suggestion that the gentleman has his legs spread apart, that he's spreading anything, pointing to it, and directing someone's attention to it. We're told again, and not to, I know, you know, in the dark, lying in bed, nude, hand on the chest, hand holding the camera. And I understand where they say where the young man said the penis was, but doesn't say the condition. Is it turgid, erect, semi-erect, as though the cases had cited? I think Karakloglu was the predominantly displayed. I think Berdalis was semi-erect. Sullivan, it was clinical descriptions of sexual activity. This is a nude image of a man in bed.
But it's not the only image, as Justice Hershfang pointed out in the police report, right? We spent a lot of time talking about this particular image, but there was also a report of a photo of his buttocks with the caption, "Better than ice cream."
He's not charged with that one, Judge.
Is that not, is it
No,
just the one?
even if you look at the Commonwealth's brief, it begins with the accusation, because there's a lot in that police report, I get it, but he's not charged with enticing.
When was that image sent? Was that on the same occasion or a different one?
I don't.
It's unclear.
They're incredibly unclear, Judge.
Yeah,
But
it's on Record Appendix 12. It says that the son said the contents of the photo involved the individual's penis as well as his buttocks with the caption, "Better than ice cream." But I don't know. It talks about the incident, but it's unclear.
With respect, Judge, the incident in question that this gentleman is charged with by way of that one-count complaint is the allegation that sometime between November and December, he sent a photograph of himself lying in bed.
Right, but I mean, I think the question, you know, this is one of the longer police reports I've ever seen out of a district court case, and I think that there is a reason for that, which is that the police wanted to provide the context for this, and I trust, to circle back to Justice Sachs's earlier questions, I trust you're going to argue that we shouldn't consider that context when we're looking at the image, that we should just examine this image as if it were sent from one person to a stranger without any context around it. Is that your argument?
Yes, Judge, relative to
why?
what, because the charge is disseminating to children matter that is harmful to children. Knowing it to be harmful, a violation of standards in the community. Whether or not the image is a harmful matter under the two-prong test, obscene or 1, 2, 3, depends entirely on the image itself. Rex tells us that. Recall, Rex was a gentleman who was in MCI Norfolk who had the images from the nudist colony, and he kept them hidden. He didn't want anyone to see it. They say the context, his state of mind, doesn't answer the question whether the matter is harmful to individuals. Minkowski, that was when the gentleman also said, hey, I sent the picture of myself masturbating, but I didn't know it was wrong because she was over 14. They say, no, the context answers the question, what was your state of mind relative to whether you did this knowingly, understanding that it was harmful to minors. All that background, all that background within the police report might go to the gentleman's state of mind, consciousness of guilt, but it doesn't answer the question before this court with respect, which is whether or not what was described in the body of the police report is matter harmful to children.
So what you're saying, I trust, is that if they'd had all that back and forth, and then the defendant sent a photo of a kitten to the child, a naked kitten, that we would only be looking at the photograph.
Correct. Correct. Yes, because the matter in question would be the photograph of the kitten.
Can we look at how the victim himself responded to the image to determine whether it was harmful to him?
Judge, with respect, it's an objective standard. It says so in Rex. It says so in Militello.
Well, his objective response was to send back a nude photo of his own genitals. In determining whether it's harmful, can't we look at what effect it actually produced?
With respect, no, Judge. The reps, Militello, Minkowski, you name it, Ferrari, it all has to do with what is the matter in question. The matter is the matter. The image, in our case, the description of the image, is what this case rises or falls on. And with respect, again, not to belabor the point, I know you know it, but a nude image of a man in bed in the dark without any further description of what's going on, I suggest is just insufficient for probable cause, and they should have grabbed it by way of preservation orders, et cetera.
All right. Thank you very much
Thank you, Your Honor.
for your argument. All right. Our second case, 24P771, Commonwealth versus Encarnacion.
Good morning. May it please the court, Dennis Toomey on behalf of SKYZEN Encarnacion. We're asking you to reverse the conviction for unlicensed firearm possession because the evidence was insufficient to prove absence of licensure beyond a reasonable doubt and because the jury instructions erroneously omitted that element. If only one thing that I say sticks with you after today, I hope it's this. The jury was the trier of fact. So when we're analyzing sufficiency of the evidence, only the evidence and information told to the jury at trial can be considered. The Commonwealth is suggesting that we water down that standard by pretending that the trial also included evidence that someone under the age of 21 was prohibited.
Well, would that be evidence or would that be an instruction if it had been requested? I mean, you can't ask a police officer, does the law prohibit someone under 21 from getting licensed, can you?
Well, I disagree, and in fact, next door today, right now, the SJC is considering the Collins case, where they're deciding whether a police officer's testimony that a defendant was a prohibited person because he had a prior felony conviction was sufficient. So I think the Commonwealth could have asked the police officer in this case,
Okay.
was SKYZEN too young?
Perhaps they could have, but they could also have requested an instruction from the judge that says a person under 21 is prohibited from obtaining a license.
Even if that's true, they didn't do that here.
They didn't do that, but I'm trying to focus on whether the issue is the sufficiency of the evidence or some gap in the instructions. And if the evidence was there, the evidence that he was under 21, and what was missing was an instruction rather than evidence, then does double jeopardy bar a retrial?
Well, my contention is that the evidence was insufficient. That's not enough to say that someone is under 21.
Well, we may agree that it's not enough to say, but if the additional information necessary could come from the judge rather than from the Commonwealth's case, why is the evidence insufficient? The evidence insufficient, so as to bar a retrial?
Because the jury didn't get that instruction here. They could do that at a retrial. They could ask for that instruction, but here.
Okay, so you acknowledging then that there could be a retrial with perhaps a proper instruction?
Only if you reject my contention that the evidence was insufficient.
Well, you agree. You seem to be agreeing that an instruction that a person under 21 cannot lawfully be licensed would be permissible, and that together with the information that the defendant was under 21, it would allow an inference that he wasn't licensed.
That is a correct statement of the law,
Okay.
yes.
So at a trial where that happened, that would involve no more evidence than this trial. It would merely involve an additional instruction.
That's correct.
Okay.
But
So then why does so you agree that double jeopardy does not bar a retrial in that circumstance?
no. Again, if they didn't ask for that instruction or have any testimony here, there was no way for the jury to find that element here.
So does double jeopardy mean that if you didn't ask for the instructions you needed the first time around as the Commonwealth that you can't, or the judge didn't give them, you can't get a do-over?
I think it's very fact-specific. I think here, age was not an element.
Okay.
Right.
Well, suppose the Commonwealth had known clearly that it had to prove lack of licensure and asked the judge for instruction that a person under 21 cannot lawfully be licensed. And the judge said, no, I'm not giving that instruction. In fact, I'm directing the case out. Or the judge the judge grants a 25B2 motion, something like that. And it comes up to us, and we say, no, the judge can give that instruction. Can the case be retried? Or did the judge's error in refusing that instruction somehow deprive the Commonwealth of another opportunity given proper instructions?
That's a very interesting question. That's one that I have not considered. But if I was representing the defendant in your hypothetical, I would argue that all that matters is the trial evidence and whether the jury had enough information before to find the element beyond a reasonable doubt. So that may be unfair to the Commonwealth in your hypothetical, but I would still argue that the evidence was insufficient. Therefore, there should be a judgment of acquittal.
But it's not, in the hypothetical, it's not the evidence that's insufficient, right? It's the application of the facts, of the law to the facts. In Justice Sachs's hypothetical, the jury was deprived of the opportunity to apply the appropriate legal standard to facts that would have been sufficient had the jury been properly instructed.
I agree, but I think the duty is on the Commonwealth to create sufficiency of the evidence, whether it's through a combination of testimony and instructions or judicial notice or any combination of the three, but the Commonwealth has to do that here. I know it seems unfair.
They have to try, but my experience as a prosecutor was that I did not control the judge.
We don't know
That's
if you're
true.
having a different experience.
Defense attorneys experience the same problems.
It's frustrating, it can be very frustrating.
Absolutely, but
So perhaps the Commonwealth should have requested such an instruction. If the Commonwealth was on notice that it needed to prove this lack of licensure, and it didn't request the instruction that would make its evidence sufficient, then you could arguably fault the Commonwealth. If the Commonwealth was not on notice, then one really would have a hard time faulting the Commonwealth for not requesting the instruction. And I understand that's the issue that's under advisement in the Crowder case. So do we need to wait for the Crowder decision?
no, I don't think you need to wait because the evidence here was insufficient. You may need to wait for the SJC to decide whether double jeopardy bars retrial for a case that occurs after Bruin, which is this case as well.
Well, but it's also Crowder.
Correct, yes.
Right.
But,
Yeah.
sorry, did you say Crowder?
Yeah.
Yes, so then, yeah, I do agree that it would be prudent to wait for that decision to determine whether the relief should be a new trial or judgment of acquittal.
What's your client's, is he coming up for release or parole eligibility anytime soon?
No, my client is not in custody, Your Honor.
Oh, he's not in custody, okay,
Not anymore. He was held before trial.
okay.
If there are no questions about sufficiency, I just want to briefly turn to the jury instruction error. The Commonwealth concedes that there was error and and that the standard is harmless beyond a reasonable doubt. Obviously, if the evidence is insufficient, then the error can never be harmless. But even if you somehow find that the evidence was sufficient because of the offhand reference to age that was elicited by the defense attorney, not by the Commonwealth, the only cases that have found these errors to not be harmful is cases where the evidence was overwhelming. The evidence of absence of licensure was overwhelming. And here there was...
Well, here there was several witnesses testified as to age, and defense counsel conceded in his opening, which is not evidence, but still says, he's guilty of unlicensed possession. So isn't that an indication that the defendant does not challenge the evidence that there was, sufficient or not, that he was not licensed?
Well, the opening statement, as you said, is not evidence of anticipated roadmap, and here it was anticipated that there might have been a stipulation, but the Commonwealth never moved forward to enter that. Defense counsel pivoted in closing argument and did not concede the licensure element here.
Is it the Bookman case that talks about evidence that was undisputed from evidence of non-licensure that was undisputed from a witness whose credibility wasn't challenged?
Yes.
And so here we have the age evidence, and at least judging from, there is no evidence that challenged that testimony, and the defense counsel seemed to indicate in the opening that there was no basis to claim licensure.
Yes, but Bookman also had police testimony that the defendant did not have a license. This case is closer to the Lugo case where this court said circumstantial evidence is not overwhelming. And that's what we have here at most if you reject the sufficiency claim.
So then is the remedy a retrial, putting aside your double jeopardy?
Yes. Yes, at a retrial, the Commonwealth could do what the Commonwealth is asking this court to pretend happened. And that's what justice requires because Encarnacion's constitutional rights were violated. Reversal is required in some form. If there are no further questions, I will rest on my briefing.
Okay, thank you. We'll hear from Ms. Kohler.
Good morning, Your Honors. May it please the Court. Carrie Kohler for the Commonwealth. I'd like to address some points about the record. The defendant was released almost immediately after the conviction was returned. He was sentenced to time served. That is in the transcripts. And I would also suggest that based on the record, this was a very cordial trial between the parties. It was one where it was clear what the defendant was challenging, and it was clear what the Commonwealth was alleging. I also believe I cited in my briefing that there was an extensive contemplation of the charging conference. Though the transcripts were brief, it would appear there was some communication outside of court hours and off the record where the parties had the opportunity to review the judge's instruction, and no one raised any objection with count 2. I would state to the court, this is a clairvoyance exception type case, and it's somewhat unfair that the defendant is arguing that he should benefit from the clairvoyance exception and the Commonwealth should be held to be clairvoyant. I would say to the court that this is a case where the evidence was sufficient. The defendant was 19 years old. There were a few witnesses who testified about his age and how young he was. It was part of the defendant's theory that the defendant was a young man, and his...
But you agree that the jury was never instructed anything about age and licensure?
Yes.
So can the jury rationally conclude that he was not licensed based solely on evidence of his age?
Well, I think that in Bookman and Encarnacion, the SJC and the appeals court told us that the convictions can be affirmed on that record.
Well, neither of those involved this record.
I'm sorry?
Neither of those cases involved this record.
No, not the specific record.
Right, but neither of those cases turned on evidence of age without a jury instruction regarding the relationship between age and licensure. So that's my specific question.
I think these cases that I cite could be analogous to this record. I think that we're parsing it very finely to say that the defendant was factually too young to legally obtain a license, and therefore this case is really different from what Encarnacion and Bookman tell us. I agree that it's not as, it doesn't fit as nicely. It's not as neatly in sort of the jurisprudence that exists.
Isn't the step that's missing here the application of the law to the facts? I mean, let's say I agree with you that there was undisputed factual basis for determining that this defendant was 19 years old.
Yes.
There is no instruction to the jury to what that means in terms of licensing. There's no determination by the judge about what that means in terms of licensing. So you're asking us to apply the law to that fact. Is that what you're doing?
Yes. Well, it's my first suggestion, that you take a look at what the SJC says about facts in dispute. It wasn't a fact in dispute. The defendant was 19 years old.
But the fact that wasn't in dispute in Encarnacion and in Bookman was the fact that the defendant had no license to carry. Here, that is not a fact that was undisputed at the trial, right?
Right.
So you're asking us to affirm, in essence, something that hasn't happened yet, namely the legal determination that the defendant was unlicensed. I agree with you that is a
Right.
necessary corollary of the
Sure.
fact that he was 19 and that you can't be licensed if you're under 21. if you put those things together, I agree that the conclusion must be that he's unlicensed, but no one has yet drawn that conclusion in this case.
Unless he accidentally got a license.
Right. I think, well, then I think you're in that world of, do you affirm on these facts or do you send it back for a retrial? I think that, I guess that's where we're really going. It's if the evidence is sufficient, if he's 19 years old and that's not a fact in dispute, do we hold the error as, do the judges hold the error as harmless beyond a reasonable doubt? Or is there a concern that this undisputed fact that was testified to by multiple witnesses could somehow not be found by the jury? There is some dicta in Encarnacion where they talk about, there is some discussion in Encarnacion where they talk about the inadmissible hearsay that came in regarding the CGIS keeper of records who testified and the testimony that came from a police officer about the defendant's admission about license. And I think that's my best case for arguing to you that the situation in my Encarnacion is harmless beyond a reasonable doubt. I think if there is a great concern that the undisputed fact that the defendant was 19 and not eligible for a license and could not have obtained one sits uncomfortably with this court, then the court is well within its right to send it back to be retried. But I think that you can affirm on this record.
If we're not persuaded by your argument that we can affirm on that basis, is there any part of this case that does not fall within the pending Crowder case at the SJC?
I don't think so.
Do you think we need to wait for it?
I don't think it wouldn't be prudent to wait for it. I don't think it wouldn't be prudent to wait for it. I think you could.
Don't think it would be prudent, or don't think it wouldn't be prudent?
I don't think it would not be. I think you could.
Very lawyerly. You have
It
to
is.
say things directly. You think it would be prudent?
Yes, I think you could. I think that makes sense. When I was reviewing the Crowder briefing, I recall thinking it certainly has application here. And I think it was argued in January, if I recall.
Early January. Yeah.
So if the Commonwealth were clearly on notice, let's imagine a trial held today.
Sure.
The Commonwealth is clearly on notice that it needs to prove non-licensure.
Sure.
The Commonwealth offers evidence that the defendant is under 21, but never offers evidence or asks the judge to instruct the jury on the relationship between age and licensure. Is that the defendant appeals saying evidence was insufficient, and we think to ourselves, well, the evidence might have been sufficient, it was just the instruction that was missing. Do we fault the Commonwealth for not asking for that instruction? If the Commonwealth was clearly on notice that it needed to prove non-licensure. I mean, there's no requirement in law that a judge give such an instruction sua sponte.
Right.
So just as we fault the Commonwealth if it doesn't introduce enough sufficient evidence the first time around, and we say double jeopardy precludes a retrial where the Commonwealth gets to try again, would a similar principle apply to the Commonwealth's failure to request an instruction that would allow the evidence to lead to a conclusion of non-licensure?
I think you send it back for a retrial.
But I'm asking,
Right.
does it matter that the Commonwealth knew that it had to ask for this instruction? If it wanted to rely on age evidence alone,
Sure.
it needed something else from the judge.
Right.
So is it the Commonwealth's fault?
Probably the Commonwealth's fault.
So then
But
why should there be a retrial? Why isn't that just like failing to offer enough evidence the first time?
I think that most records would probably be challenged on whether the Commonwealth had actual notice. Are we legally on notice? Yes.
I'm talking about a trial today where...
Sure. We assume, we hope.
Yes.
I still think in that circumstance, you'd have to remand it for a trial held properly. I think
But
that
why?
is... I'm
Yeah,
sorry.
go ahead.
I think that that hypothetical presumes that the judge is somehow not on notice either.
Not what?
Not on notice either.
Notice.
And I argue in my briefing, Justice Mulqueen would have instructed properly, if she had the guidance of Guardado. She drafted, and the record is clear on this, she drafted the proposed instruction for count 2. And she presented that to the parties for consideration because the parties didn't draft anything regarding count 2. The main issue of fact at trial was the murder charge. It was about whether or not there was a self-defense instruction, what part of the self-defense instruction was going to be argued, and what the legal issues were there. I think today, Judge Mulqueen writes a different instruction, and I think the prosecutors also put the court on notice. I'm sorry, I interrupted you, Judge Tan.
No.
If there are no further questions, I'll rest on my brief.
Seeing none, we thank you
you.
for your argument.
Thank you.
All right. Our next case is actually the 4th case on the list. I think it's the 4th because the 3rd one is going to be called 6th. So the next case is 24P260, Sexton versus Barnstable County, Wellfleet Housing Authority, and many others. Mr. Dane, whenever you're ready.
Thank you, Your Honor. Daniel Dane for the plaintiff appellant CHELLISE Sexton. This case is about a deed from 1922 from Laura Lamson to Edwin Cook about a property in Wellfleet.
I want to get right to the legal questions.
Yep.
Because we know the facts. So it seems like your case turns on the first proposition in your brief that in over-inclusive deeds, the deed conveys what the grantor owns.
That's one of the arguments.
Okay. Well, let's start with that one.
Okay.
The Massachusetts cases you cite for that don't really seem to support that proposition so squarely. The Powell case says that the stated boundaries in a deed control over the stated acreage, which is just an application of the kind of hierarchy of tools that we use to interpret a deed.
Yeah, I mean, I think for the proposition that a deed that is over-inclusive conveys a property owned by the grantor is established by 200 years of cases that I cite as well as treatises.
But let's talk about the Massachusetts cases and then let's talk about the other authorities you cite. So Powell is really about the hierarchy of rules we use to interpret a deed. And it says the stated boundaries control over the stated acreage, whether the acreage is more than is within the boundaries or less than was within the boundaries. It's the boundaries in the deed that control what's conveyed.
Right.
Okay. So then the Atkins case didn't really involve a description of land or a dispute over the description of land. It was a difference in the description of the debtor's share of some land held in common. It was, I think, whether it was 9/64ths or 1/7, which would be 9/63rds. But what was at issue in that case was not the sufficiency of a description of land in a deed.
Right. So the interpretation of a deed is a question of the intent of the parties. The intent of the parties is determined by rules of construction. It's not a subjective question. We have rules of deed construction which tell us how to interpret a deed, right? And so what we have here is a grant of land that was over-inclusive, and the land court found could have described two different rungs on the ladder between Old Kings Highway and Covell's Way, right? So we look at the rules of construction to discern the intent of the parties. The intent of the parties as to the Freeman lot versus the area of land bounded by the pool illustration at Exhibit 117, the rule of construction that says that a the fact of a deed indicates an intent to convey property owned by the grantor. Here, we know that the grantor owned property within, bounded by as shown in the pool illustration, and in the Freeman parcel, owned no property at the Freeman, did not own the Freeman lot, and in fact, the Freeman lot was owned by Cook, the land court found, based on a conveyance from 1884. So we're looking only at the pool illustration. Now, within the pool illustration, the question is whether or not the parcel can be precisely located. The land court relied on McHale v.
Well, I want to get back to your first proposition because it seems to me it's very important to your case.
Yeah.
The over-inclusivity proposition. Atkins and Powell, at least I'm not persuaded that they really stand for the proposition you state. Your next authority, I think, is CJS, which for the proposition you state relies on a Utah case that I'm not sure had an inadequate description of the land.
But there's two different questions here. One is whether or not, looking at the deed itself, can you discern the intent of the parties from the language of the deed itself? And what we know from all the case law is that in every instance, you always have to look at what the grantor owned, right? So even with...
Wait, what case law says that?
Pretty much every case that I've cited. I mean, you have to check to see if the grantor owned even with an entirely precise deed, you have to look to see if the grantor owned it. The land court engaged in that process in looking at the Freeman lot and looking at the different parcels that...
But what we're determining here is the sufficiency of the description in the deed.
Right, in comparison to what the grantor owned.
And what case says we need to do that?
For instance, in Danforth v. Chandler from 1921, the deed said, I convey 40 acres of land in Pembroke, right? So if you just look at that, there's no way of putting on a map which 40 acres in Pembroke you're talking about. But if you look at what the grantor owned, the grantor only owned one parcel of 40 acres. And therefore, there could only be one, there was no imprecision as to which parcel the grantor intended to convey.
So if I grant someone the rights to my property in Massachusetts,
Right.
and I'm a public employee, so really there's only the one, is that adequate?
In the case law, yes. If there's no imprecision as to what property you're talking about, so Danforth as well as the Hurley v. Brown case from 1868, the Hurley v. Brown case said, I convey a house and a lot on Amity Street. From that language itself, there are many houses on Amity Street. You wouldn't know from the deed itself.
Both Hurley and Brown turn on the notion, and I'm quoting from Hurley now, the presumption is strong that a description which actually corresponds with an estate owned by the contracting party is intended to apply to that estate.
That's exactly right.
Even though it's couched in such general terms as to agree equally well with another estate which he does not own. But here, do we have a description in this deed which actually corresponds? I don't see a property that corresponds.
The property that corresponds is that the grantor owned only a single parcel between Old Kings Road and Covell's Way. And so that's no different from saying I convey my property, my house and my lot on Amity Street.
The description in the deed is of land owned by Cook to the north and the south.
Right.
But she doesn't own any such property.
Well, that's the over-inclusive question.
Okay, so let's get back to the over-inclusive question.
But
do you have any cases in Massachusetts or a case from elsewhere that says that if you take the over-inclusive part out of the description in the deed,
right,
can you still, after you excise whatever makes the deed over-inclusive, do those cases all have a sufficient description? Because I don't think that you do here.
The sufficient description in this case is the fact if you look at Lamson's title, it precisely places...
But that's not in the deed.
But the same way that saying my house and my lot on Amity Street, you don't know which house is on Amity, which house is intended to be conveyed unless you look at the grantor's title. And the grantor only owns one property on Amity Street. That's no different from here where it says, you know, essentially, I'm conveying my property between Old Kings Highway and Covell's Way. There's no difference between Hurley v. Brown in this case.
So you think a description that says, She doesn't say my property, actually. So you think a description in a deed with only the eastern and western bounds and no northern and southern bounds accurately described is sufficient?
You would need to look at the title of the grantor. If the title owns only one property that matches that description, the common law, the rules of construction tell us that's an effective deed.
Does it matter that that Hurley and Danforth were both about purchase and sale agreements, where the issue is determining the intent between the buyer?
I don't think it makes.
Let me finish. The issue there is, was there a meeting of minds between the buyer and the seller? Here we're talking about a deed and a land recordation system or registration system that is designed to put the whole world on notice of what is owned and not owned.
Right, so you look at, first of all, I don't think there's a difference. The deeds are considered contracts, and so you have rules of contract or deed interpretation.
Right, but the purpose of the recorded land system is you don't have to record a contract. And really what matters with a contract is whether the parties' minds met. Here, doesn't the description have to be adequate to put the whole world on notice of what was sold and not sold?
Well, certainly REBA title standards would tell us that those are best practices, but REBA title standards are modern best practices. They're not rules of construction.
Standards aside, as we think about what is a sufficient description, don't we need to think about protecting not only the intent of the parties, but also the rights of the public and anyone who's thinking about buying land in that area to be able to know what land is owned by Sexton today versus what land is not?
But so that's why you look at the title history. So Lamson owned only one parcel in Wellfleet between Covell's Way and Old Kings Highway. That resolves any ambiguity as to what the intent was as a matter of...
What if she thought she owned, or what if Mr. Cook thought that Ms. Lamson owned, had some hidden interest or obscure potential interest in the Freeman property, which the description in the deed corresponds to better than the Lamson property?
That's why rules of construction don't look at subjective intent. If they wanted something that was different from the rules of construction, they could have specified much more clearly. But the rules of construction you look at objective manifestations of intent, and objective manifestations of intent look at the language of the deed itself and the title history. Okay, only through the title history, Lamson only owns a single parcel.
The language of the deed refers to a parcel that is bounded on the north and the south by Cook, by land owned by Cook. Doesn't that correspond equally well to the Freeman lot?
It does, right. So the land court stops.
So Hurley and Danforth both talk about where if a party who enters into an agreement in fact owns a parcel answering to the description and only one such.
But Danforth says you look at the property that's owned by the grantor, right? The fact of a deed indicates that the grantor intended to sell.
Does she own a property? Did Lamson own a property that was bounded on the north and the south by land owned by Cook?
That's over. We're back to over-inclusive, but she owned between the Freeman, the land court.
Just a sec. She did not own a property. Lamson did not own a property that we know of that was owned, that was bounded on the north and the south by land owned by Cook.
Between the Freeman lot and the property in the area described in the pool illustration, only one of those does Lamson own property in it.
All right, but she did not. Just if we could get on the same page here.
Okay.
Do you agree that she did not own a property that was bounded on the north and the south by land owned by Cook?
Yes, and the rules of construction tell us what to do in that circumstance. She only owns one property between Kings Highway, Old Kings Highway, and Covell Way, and it's entirely bounded. And by referring to the title that she had, it resolves any ambiguity as to what, as a matter of the rules of construction, the court would interpret the intention to be. Not subjective intention, and we know from the rules of construction it can't be the Freeman lot because the land court found that Cook already owned the Freeman lot based on a conveyance in 1884.
Why does that rule out the party's intention to
because subjective intent is not a question in interpreting deeds. We have rules of construction that tell us how to interpret deeds. And those rules of construction tell us that between a parcel that's not owned by the grantor and one that contains a parcel owned by the grantor, you're not considering one not owned by the grantor. The rules of construction tell us
that's
you
true
don't
if
make
you
up.
have a description in a deed that, to quote Hurley and Danforth, answers to the description in the deed. And
But
you
only-
just said a minute ago that
But the same.
Lamson did not own a property that answered to the description in the deed. At least the 1829 parcel does not.
Right, but based on the language of the deed, in Hurley and in Danforth, there are many parcels that could have answered to the description, right? If you're saying, I'm conveying 40 acres of land in Pembroke, there are probably thousands of 40-acre, of
Right.
hundreds of
But the
40-acre
grantor
parcels.
owned only one that answered to the description. Here, even if Lamson owned only one,
Right.
it didn't
only one
answer to
in-
the description. That's
Only
the
one
issue.
entirely contained within the description, right? There's many cases which I've cited in my brief. I have 2 pages of cases, both in the Commonwealth and outside the Commonwealth, where the fact that the deed wasn't precise.
Am I misreading the Powell and the Atkins cases?
I think so.
Or am I misinterpreting
I mean, I just
them?
reread the Atkins case. The Atkins case, I believe, was a case where I don't think it was a deed, it was a probate, but
It was a
the
execution.
description, I thought my memory of Atkins was the description was a conveyance of 1/7 of an interest, and in fact, the party owned 1/8, and the court wasn't troubled by the difference between 1/7 and 1/8, even though 1/7 was over-inclusive. It said, well, it does own 1/8, which is entirely within the 1/7. And the court said that that's not problematic. The rules of construction tell us the alternative to the rules of construction saying that a conveyance of the portion owned by the grantor with an over-inclusive property is that the conveyance is nullified. Here we have conveyance, we have consideration paid, and we also have case law that says where the grantee has paid consideration, the court should endeavor to find an interpretation that effectuates the conveyance to the grantee. Otherwise, an injustice would occur. Thank you, Your Honors.
Thank you.
Good morning, Your Honors. May it please the Court, my name is Zachary Burke. I'm arguing on behalf of the appellee defendants. I've reserved 3 minutes for my brother, Giles Quilt, to argue on behalf of the appellee interveners. Your Honor, I think you hit on a critical issue about the proposition in Massachusetts and whether the case law supports the fact that an over-inclusive deed can convey land within the description. But
Well, I was interested that you didn't take issue with it in your brief. Do you have reason to take issue with it?
well, we do have reason to take issue with the appellant's characterization.
The over-inclusivity rule that that Ms. Sexton is arguing for.
Yes, Your Honor, but I don't think we even need to get there here because the Sexton's entire appeal is premised on a factual conclusion that was rejected by the court. So the court...
Well, is this a question of fact or a question of law here? The issue is the sufficiency of the description in the deed. Is that correct?
Correct. That is the
Okay.
issue, which
is that not an issue of law?
Well, first the court, the land court has to look at whether or not the deed description is ambiguous. If it's not ambiguous, then the court applies that description to the locus at issue and determines whether or not that conveys the property. So here...
But is the question of whether the description is sufficient a question of fact or a question of law?
It's a question of fact, Your Honor.
Do you have any case that says so?
Well, in this case, the description's not ambiguous. Where it's not ambiguous, then the question is, okay, from the factual perspective, does that description describe the parcel that you're claiming was being conveyed? So here, it described Cook to the north, Cook to the south. Obviously, it's undisputed in the record that that does not describe the position of the locus. So then, the plaintiffs at trial, their experts testified that, well, the intent here really was that that description referenced these Cook parcels, several parcels removed to the north and the south. And the trial judge expressly rejected that expert testimony, saying that that was the intent of the description. And based on the unambiguous description, the court never had to look at extrinsic evidence. And my brother's argument is really based on extrinsic evidence. If you're getting to extrinsic evidence and you're finding that this deed was an attempt to convey, well, first you need to conclude that Ms. Lamson only owned one parcel of land in Wellfleet. And you don't get there by looking at the deed, the 1922 deed. In order to get there, you need to look at extrinsic evidence. My brother's argument also relies on the fact that Mr. Cook owned parcels, several parcels removed to the north and to the south. And to get there, you need to rely on extrinsic evidence.
Well, you would agree, I think, that if the Lamson deed, the 1922 deed, had said my property in Wellfleet, that would have been sufficient?
That would not have been sufficient, Your Honor.
Why not? If there's only one property that she owned in Wellfleet?
Well, because, Your Honor, there's no indication from the deed. It would undermine conveyancing principles and the principle that's set forth in the McHale case that a deed needs to sufficiently describe the parcel at issue in order, as Your Honor discussed earlier, to put the whole world on notice as to what property was being conveyed.
If in the Danforth case, the purchase sale agreement said 40 acres, and there was only one 40-acre parcel that the seller owned, then why wouldn't it be sufficient to say my property in Wellfleet? Now, I'm correcting myself because I think her property inventory suggested she owned a house on Commercial Street, East Commercial Street. But that aside, why wouldn't it be sufficient to say my property near Old Kings Highway or abutting out Old Kings Highway?
Because under Massachusetts law, for a conveyancing instrument to be valid, the deed must identify the land with such particularity as to make the land capable of identification from the description in the instrument.
Okay, but that wasn't so in the Danforth case. Danforth just said 40 acres.
Yes, Your Honor. And
that's enough.
Yeah, and again, 40 acres, number one, when you look at the hierarchy of descriptions in a deed, the acreage is the least critical.
That's right, and yet it was sufficient there with no more.
And those cases are distinguishable, Your Honor, because in those cases, well, first of all, they were trying to, the parties had only entered into purchase and sales agreements. We're talking about purchase and sales agreements and what those described, and if a party could get out of those. But also, the intent of what property was at issue in those cases that was not in question. The parties to the transaction were the litigants in the case. They knew what property they were talking about. That wasn't in dispute. Here, we're trying to figure out what did these parties 100 years ago intend to convey based on a description in the deed that doesn't even reference Ms. Lamson's, the deed in her chain of title that the appellant is claiming is the foundation for her ownership of the locus.
But that's not a requirement in a deed, is it, that you reference your chain of title?
It's not a requirement, but it is an indication of it provides more information if you're trying to determine
Sure, it would be nice
the,
if we could go back to 1922 and advise the parties to clean up their deed.
Right, but you need to be able to read the deed and place it on the earth somewhere.
Well,
and the
that's the goal, but yet in Danforth, admittedly, we're talking about a P&S, not a deed, but 40 acres was enough. And in Hurley v. Brown, the house and lot on Amity Street, Lynn, was enough. There were a lot of houses and lots on Amity Street in Lynn, but the grantor only owned one. So that was sufficient. Why wouldn't it be sufficient here to say my property bounded by Old Kings Highway on the west and Covell's Way on the east?
I don't want to repeat myself, but I think those cases there are distinguishable because there was no question about the intent of what property was subject to the transaction.
There was a question. In Danforth, at least the subjective intent of the seller was to retain 19 acres for himself.
Yes, that was his subjective intent, but the property that was at issue, what land was the subject of the transaction was not in dispute. It's maybe the amount of it, but what property we're talking about. Here, there's no indication that Ms. Lamson was attempting to convey the locus. And I think I made this point earlier, but I'll reiterate it. If you're going to look at this, if you're looking at this to say that, well, Ms. Lamson only owned one parcel in Wellfleet, so that's what she had to convey. First of all, that's contrary to the factual findings of the court. But if that's the proposition.
What finding is that contrary to?
Well, the judge read the description of the deed and found that based on that, he couldn't go beyond the description into extrinsic evidence.
But he did consider extrinsic evidence, didn't he?
He did it to bootstrap the decision. So he said, look, I don't need to get into extrinsic evidence, but my decision.
Do you mean bootstrap or do you mean belt and suspenders?
Belt and suspenders, I'm sorry. Yes, that was belt and suspenders, Your Honor, but the point is, if you, Ms. Lamson's property ownership in Wellfleet is extrinsic evidence, right? It's not referenced in the deed. So once you get into extrinsic evidence in this case, then you have to consider all of it. And here, there's no extrinsic evidence supporting the fact that Cook ever took possession of the property or understood that he owned the property. All of the extrinsic evidence.
But all the extrinsic evidence comes from non-parties to the deed in question, beginning no earlier than 19 years later. What case says that that kind of evidence is relevant in deciding whether a description in a deed is sufficient?
Your Honor, the Ellis v. Wingate case talks about consideration of extrinsic evidence, and it said you can look at the subsequent actions of the parties. I would include...
Of the parties.
Right. So in this case, it was Ms. Hinckley who was Ms. Lamson's daughter. And the evidence is that Ms. Hinckley granted an easement over this property several years later. The evidence is that Ms. Hinckley continued to pay taxes on this property for 25 years until a tax taking occurred. And then the evidence is that Ms. Hinckley sold a portion of the property to a gentleman in the 1950s.
When we say extrinsic evidence includes subsequent actions by the parties, does that include the successors in interest to the parties?
Yes, I would submit that it does, because that's the best evidence we have of the intent here.
Is there a case that says so?
I do not know of a case offhand that mentions the actions of heirs of the parties.
So what was the judge trying to determine? The intent of the parties to the deed or the legal sufficiency of the description in the deed?
The legal sufficiency of the description. And then if that is ambiguous, then the judge would have to determine what the intent was. But here the judge found that it was not ambiguous, and he could not place the parcel on the ground.
Do you think there's a distinction between Danforth and Hurley in their consideration of purchase and sale agreements and the sufficiency of a description in a deed?
I do think there's a distinction. The distinction is what Your Honor hit on earlier, the fact that a deed is intended to put the public on notice of through the recording system, of what land is at issue. And if the court adopts the appellant's proposition which again is not supported by Massachusetts case law, then that would really undermine the entire recording system, because you couldn't rely on the description in the deed. You would need to do further research to figure out, in this case, what else did Ms. Lamson own? What were her holdings all over Wellfleet to figure out if she owned a parcel somewhere or a portion of land somewhere within this larger land that was described or arguably described.
How burdensome is that? You just look at the grantor index and the grantee index and see if you find her name. And we look at other recorded documents all the time to help us pin down what a deed means, don't we?
Yes, but
often they're expressly cited in the deed, but
yeah. Well, in this case, unfortunately, that's not what happened. But the principal issue of whether or not the description in the deed is legally sufficient is critical. And here,
But what's the danger here? If we were to rule for Ms. Sexton, what danger does this create in Wellfleet or anywhere else about the sufficiency of description in a deed?
The danger would be you can't rely on the description in the deed. You would have to do further research into what the parties held, what they may or may not have intended, and it would really undermine being able to pick up a deed. What land is this deed describing, and does this person have title to it? Where did this person obtain title to this property? And you just wouldn't be able to rely on the descriptions in the deeds. So I know my time is up, Your Honor. If anyone has any further questions.
Seeing none, we'll hear from Mr. Krill.
May it please the Court, Attorney Giles Krill, representing the defendants in intervention appellees. My clients are the owners of a registered land subdivision lot that's neighboring the disputed parcel. Their certificate of title references an access easement which crosses over the disputed parcel, which is recorded land. In the judge's decision, separate and apart from his analysis of the 1922 deed, he made specific findings and rulings that my clients were good faith purchasers within the meaning of the land registration statute, and that even if he was wrong about the 1922 legal interpretation, nonetheless, the land registration statute rendered our easement beyond challenge by the plaintiff appellant. The plaintiff appellant in her chief brief did not make any argument with regard to that aspect of the land court decision. Therefore, we cited case law that challenge is now waived. In the reply brief of the appellant, an argument was made that it was outside the scope of the Phase 1 trial bifurcation. That's not accurate. Page 38 of Record Appendix Volume 1, the court's order on the docket sheet specifically says, Phase 1 of the trial will address the plaintiff's claims of record title and whether the individual intervener's easement is immune to attack by virtue of the registration decrees for the intervener's property. And in our motion to expand the record appendix, which you obviously have discretion to take judicial notice of anyway, it was very clearly briefed and argued in the lower court. So we say under any scenario that issue is put to rest.
So if the Sextons didn't have standing, then did the court have jurisdiction to determine?
Well, I did notice that the plaintiff cited a zoning case about standing, and I don't think that applies here. Standing is a statutory term of art when it comes to person aggrieved, when it comes to zoning and permitting cases. Okay. It leads to huge bodies of case law in and of itself.
Sure, but,
in this case,
but as a general matter, in this Commonwealth, we treat standing as an issue of subject matter jurisdiction. So if if Ms. Sexton didn't, or the Sextons below didn't have if they weren't aggrieved because they didn't own the locus, then did the court have jurisdiction to determine the effect of documents granting an easement over the locus?
I say yes, because I say he used standing in a colloquial sense. He just as easily could have said, even if I am wrong about the 1922 deed description, which would ratify the easement in question, I also ground my decision in this alternative basis. Judges should be free to do that. They do it all the time. To conclude otherwise would mean even after we put on a trial, my clients testified to their good faith purchaser status, we would have to go back, have that trial all over again. That can't be the case.
All right. Seeing no further questions, thank you all for your arguments. Very well argued all around. And we will take a 15-minute break and come back for our last three cases.
All rise.
session. Please be seated.
Good morning again. We're ready for our next three cases. First of which is 24P43, Campbell versus Abdullah is the name on the caption. I understand coffee is also a party. So, whenever you're ready. Just need to get the light. Okay, there we go.
Good morning, Your Honor. Excuse me. Good morning, Your Honors. May it please the court. My name is, oh, can you hear me?
Just,
Yeah.
you can pull it a little closer to your mouth. That might, there you go.
Oh, okay. That's good.
Well,
Thank you. Good morning, Your Honors. Oh, it's too loud. Okay.
yeah,
Good
that might
morning.
not work. Just,
He's going to help you.
yeah.
Just leave it like this.
Oh, okay.
Yeah.
Yeah. Why don't we, if I could ask our assistant clerk and timekeeper to restart the time. There we go. Thank you.
Thank you. Good morning, Your Honors. May it please the court. My name is Sun Liu. I represent Tanya Coffee, appellant tenant in this case. With me, Michael Weinhold at the table. I'd like to focus my argument on three things. First, Retaliation Defense Statute 239-2A applies to all types of evictions, including fault-based evictions. Second, landlord failed to rebut his burden to meet rebut the presumption of retaliation. Third, housing court made no factual findings on the issue of retaliation. This is a simple case of statutory construction. Retaliation Defense Statute 2A, Section 2A applies to all types of evictions. There is a recent decision from this court, Simon versus Terasuik, which is exactly on point, and it's the same housing court judge.
Can I just ask you, counsel, so what do you say to the fact that the housing court judge at trial acknowledged and said, I'll allow the defense? I think that was, your opposing counsel mentioned that in their brief.
Yes.
That we should acknowledge there was that he implicitly recognized that.
Yes, the
Even though acknowledged in his written findings, he explicitly said that it didn't.
Yes. So the housing court judge allowed the evidence of retaliation defense at trial, but we are not appealing evidentiary ruling, nor we are not, that's just interlocutory ruling, but it's not final. But in his written decision, twice he said that's the final ruling in this decision, and that's the same issue. So he said that retaliation twice in his final written decision, that retaliation defense is not available in fault-based eviction. So he didn't implicitly found, it just specifically clearly said that in his written decision twice. Yes. So there is a recent decision from this court, Simon versus Terasuik. I included in my 16L letter, which is exactly on point. It's the same housing court. Oh, you want?
You've said that. Yeah. No,
oh yes,
no.
yes. So in Terasuik case, Justice Neiman, Singh, and Tune of this court said that a retaliation defense under 2A is available in a fault-based eviction where 8A is unavailable. The plain language of the Retaliation Defense Statute 2A says that it applies to quote on action for summary process, meaning any action for summary process. The statute does not and never has included any language excluding its application to fault-based evictions. That's important because the legislature knows how to target particular types of eviction throughout Chapter 239. Sections 3, 8A, 9, and 15 all specified which types of evictions they apply to. So the legislature's conscious choices when it chooses to target particular types of eviction exist throughout Chapter 239, but there's no targeting in Section 2A. Contrary to Housing Court's decision, 8A does not eliminate or alter the entire universe of affirmative defenses available to tenant in fault-based evictions. 8A's so-called rent withholding statute provides an independent defense where tenant has damages from counterclaims that equal or exceed landlord's damages. 8A merely provides an additional defense in non-payment and no-fault cases. So as SJC recognized in Bank of America versus Rosa, 8A is not the exclusive authority for affirmative defenses in summary process. Notably, the landlord's brief does not contest our argument that 2A applies to this case. Now, let me talk about my second point. This court should reverse the judgment because there is insufficient evidence for the landlord to rebut the presumption, which was undisputably established at trial. Therefore, as a matter of law, presumption was not rebutted, and this court
Can we say that, or does it turn on an assessment of witness credibility? If the judge had believed everything the landlord said and disbelieved everything the tenant testified to, then could the judge possibly fine for the landlord? And therefore, don't we have to remand for the judge to make further findings?
I understand, Your Honor, but however, the burden was on the landlord. It's not on the tenant. When tenant triggered the rebuttable presumption, because it's clear on the record, it's undisputable that the tenant triggered the rebuttable presumption.
Right. By clear and convincing evidence that
Yes.
the landlord needs to rebut the presumption. Could not the judge find that the landlord did so? Because based on a credibility assessment?
No, because the burden to rebut the presumption is the landlord should meet all the elements because the burden was on the landlord, not the tenant, and then the burden was on the landlord, and then the landlord had to meet all the elements in the same manner and at the same time element. But here on the record, trial record, there's nothing. The landlord didn't say anything about to prove those elements in the same manner and same time element. And at trial, tenant testified the landlord told her that if you drop the Board of Health complaint, then I will drop the notice to quit. That's an admission of retaliation, but however, that landlord didn't do it.
That was the tenant's testimony that the landlord had said that?
Yes, Your Honor.
And if the judge didn't credit the tenant's testimony, if he didn't believe her about that, then could he still rule for the landlord?
But still, the landlord didn't do anything to rebut the testimony. This landlord did nothing, zero. So even if the housing court judge didn't believe the tenant testimony, but the landlord should have done to meet the higher standard because it's clear and convincing evidence standard. So it's not just that. So, but the landlord didn't do anything. And also, like in SMB property versus Miranda, Justice Sullivan, Henry, and Englander vacated the portion of the lower court's judgment because this court concluded that the landlord failed to provide sufficient evidence to rebut the presumption of retaliation, like this case. So like Miranda case, here the landlord's evidence did not even address same time, same manner element at all. That's not sufficient to meet the clear and convincing evidence. Like Miranda case, the landlord didn't testify that he would have pursued eviction even if tenant had not reported the severe rodent infestation at the same time in the same manner. And also the landlord didn't even affirmatively testify that he did not have retaliatory motives. So in the 239-2A, there's additional requirement, not just clear and convincing, but the two meet the clear and convincing evidence. The landlord should prove that it's in the same time, at the same time, in the same manner. Without the Board of Health complaint, landlord should have brought the pursuit eviction exactly the same. But here, the landlord didn't provide any evidence. The burden was on the landlord.
Right, but couldn't that be explained by the fact that the judge said, I don't believe that 2A applies in this cause eviction? In other words, if the landlord was not on notice or did not expect that the judge was putting this burden on the landlord, even if we believe that the judge was wrong about that, if the landlord was not on notice that that was the landlord's job in front of that judge, then why does it why is it fair to hold them to that proof that they didn't bring forward?
But the 239-2A is clear. It doesn't matter if.
I don't
yes.
disagree with you about
Yes.
that.
Yes.
But the parties were in front of a judge who said, I think 239-2A does not apply here. We're looking only at 8A.
Oh, but the trial transcript says that clearly said that judge, I will allow the retaliation defense at the hearing. So he allowed all the evidentiary ruling was that he allowed any evidence on retaliation defense.
Your position is that the parties were on notice that this was a retaliation case and that this was their moment to put in their evidence on both sides about the plaintiff, obviously has this flip from usual. The tenant has the rebuttable presumption on their side, and that the landlord, by the same token, should have been or was on notice that I'm going to have to rebut this presumption.
Yes, because as I kind of repeating, but the landlord's brief says at the end, the conclusion says that landlord knew that judge allowed and a full opportunity. So he knew that judge allowed, so that he had to rebut the presumption. So the 239-2A is clear, so the landlord's attorney landlord should have known about, and then they had full opportunity, but the statute is clear that the landlord should meet those elements of same time, same manner, but they didn't do anything they didn't even address it, and they didn't even say that, the landlord didn't even affirmatively testify that he didn't have retaliatory motive. He didn't affirmatively say that, even that. And also Miranda case, there is no evidence that it's landlord's ordinary practice to serve notice to quit whenever there is any disagreement about access. And it's 10-year tenancy, and this was the only eviction case, the first time. And then when the landlord served the notice to quit, tenant denied access only one time. And then the landlord served the notice to quit. So, and then after the notice to quit, tenant wasn't able to allow access, but that was just one time. So we need
That
to.
was after the notice to quit, right?
Right, that's after though. So when we need to focus on the time when the landlord first served the notice to quit, whether it was retaliatory or not. So here it's 10-year tenancy, just first time, and landlord didn't even provide any evidence that it's landlord's ordinary practice. And then also the landlord didn't even affirmatively testify, I didn't have any retaliatory motive. So it's clear that we believe that no trial fact will possibly find that the landlord rebutted the presumption by clear and convincing evidence and meeting all those in the same manner and at the same time element. So also, let me talk about, if I may, I would like to talk about my last point. The housing court made no factual findings at all on the issue of retaliation. So if your honors think that landlord may have met the heavy burden to meet those elements, at a minimum, this case should be remanded. So housing court's decision cannot be affirmed in the total absence of findings, as to whether landlord rebutted the presumption or not under the heightened statutory standard. So Mass Rule Civil Procedure 52A states that in all actions tried upon the facts without a jury, the court shall find the facts. Also, in the present case, to meet the clear and convincing evidence heightened statutory standard, as SJC in Barboza versus McLeod says that, quote, a finding of high probability is required. So here, housing court made no such findings of fact on the retaliation defense. The judge's order does not even have a bare assertion that landlord rebutted the presumption, so it cannot be affirmed. So therefore, this case should be reversed because retaliation defense statute 2A applies to all types of eviction, and there's insufficient evidence for the landlord to rebut the presumption. The burden was on the landlord. Therefore, as a matter of law, presumption was not rebutted, and this court can decide judgment in favor of tenant like this court did in Miranda case, and then and also Moynihan case, South Boston Boston Elderly Residency versus Moynihan case and Jablowski versus Clemens. So this court was decided in favor of tenant because they thought that this court concluded that the landlord failed to rebut the presumption. So at a minimum, this case should be remanded for factual findings because this housing court made no factual findings.
But you think we don't need to do that?
Yes, Your Honor, because this court in Moynihan case, Miranda case, and Clemens case did that because they concluded that the landlord failed to rebut the presumption. The burden was on the landlord. Like Moynihan case, there was a independent reason for eviction. Like in Moynihan case, the dangerous clutter. But this court, Justice Milkey, said that although there's no evidence that the clutter was worse, like 1.5 years ago when the landlord first became aware of, then the time the landlord served the notice to quit. There was like 1.5 years later, landlord served the notice to quit. So this court concluded that this wasn't, and then also Miranda case, they concluded the landlords, although landlord provided evidence, I'm trying to check the time.
Okay.
We've got I think we've got your point on that.
Oh, thank you.
Thank you very much for your
Thank you
argument.
very much.
All right. And we'll hear from the Landlords Council, Mr. Burrell. I hope I got that pronunciation right.
Good morning, Your Honors. If it pleases the court, my name is Mark Burrell, Attorney Mark Burrell, and I represent the plaintiff Abdullah. I understand that Your Honors are very familiar with the facts of this case and the judgment itself. So I'm going to cut to the chase, and I'm going to say something about the judgment. The findings of fact and conclusions of law contained in the judgment are, to my mind, entirely accurate. The judge found his facts and concluded that in 5 instances the plaintiff had proved his case, his cause case. Now, he being the judge, also said that the defense of retaliation pursuant to Chapter 239(8)A is not allowed. That is an accurate rendition of the law. That's an accurate statement. Under 239(8)A, retaliation is not allowed, but this was not a 239(8)A case.
So how do you distinguish this court's unpublished panel decision from last month, the name of which I cannot currently remember? DeSimone.
Well, let me just state this. I don't know what the DeSimone case said, but I can say this. The reason I say that this is not a 239(8)A case is because 239(8)A itself begins by saying that in order to begin a summary process case, the basis for it would have to be a notice to quit for non-payment of rent or for no cause. And in this case, there was a notice to quit for cause, so it doesn't come under the auspices of 239(8)A. So I'm not arguing that the defense of retaliation is not available here. It is. It's available in a cause case under Chapter 239, Section 2A. It's an independent affirmative defense, and it is permitted by law. I was just pointing out that the judge, in his rendition of the judgment, pointed out the fact that under 8A, it is not allowable, and that is true. But what I think happened here is this. This judgment is accurate, but there are a couple of omissions in it. And one of the omissions is the judge considered the facts. He ruled for the plaintiff on those fivefold, on those 5 instances of cause, and he mentioned the unavailability of the defense of retaliation under 8A. But what he omitted to do, in my opinion, is to go on and say, well, under 2A, it is allowable. And he did say that at trial. It's in the transcript. He did allow the defense of retaliation. I knew it, opposing counsel knew it, and we tried the case at that point knowing that that defense was in the air and that rebuttable presumption,
So then where in the judge's 2 3/4 page findings of fact and rulings of law did he make findings and rulings related to the rebuttal of the presumption by under 2A by clear and convincing evidence that such action was not a reprisal and that there is sufficient independent justification for taking the action, and that the landlord would in fact have taken such action in the same manner and at the same time the action was taken, even if the tenant had not commenced the action or the report?
That's the omission. He didn't make.
Isn't that a fatal omission?
No, I don't believe it is.
Fatal in the sense that it could be cured on remand?
Yes, I think.
We cure it here?
There's a rule, I think off the top of my head, there's a Rule 52, Rule of Civil Procedure 52, A and B or 1 and 2. I think it's under 1 and 2. I think a judge or a party can make a motion asking for an amendment of findings of fact or conclusions of law. I think in this case what needs to happen, or what should happen, is that the case maybe should be remanded so that the judge could have an opportunity to amend his conclusions of law. Because in the case itself, the facts of this case were litigated extensively, and as to why was this case brought, why are you seeking possession, on and on and on. It was almost ad nauseum. Both parties knew. Everything was litigated to that effect without any interruption, without any objection. I did object to the idea that there was this settlement offer of, oh, if you drop your case, I'll drop mine. I objected at the time. That's evidence of settlement, of offers to resolve, which are not admissible. But that's sort of aside from what I'm trying to argue here. There is one point that was brought up, and I find this very interesting. It is a part of the 239-2A that a plaintiff landlord must ask or show that if the defendant had not called the Board of Health, exercised that right, would you have taken the action that you did? Well, this is an odd case because, and I have another one like it, we probably wouldn't have had this eviction case if the tenant had not called the Board of Health. Because once she called the Board of Health, what followed was what served as the catalyst for bringing the case. It wasn't the fact that she exercised her right to call the Board of Health that did it. It was what happened as a result of her calling the Board of Health.
What happened when the landlord and the exterminator showed up and Mr. Abdullah said, no effing way, you're going to get him.
That's right. And he had to go to court 3 times.
But that's a question of fact, isn't it?
Well, yes, that's a question of fact. In other words, why did he bring the case? But there were sufficient facts brought. He had to go to, it was in the trial as well. He had to go to court in a civil case 3 separate times to get an injunction, to get an order to get access. And then when he tried to get access, the tenants were very combative and they drove them away. That served as the initial catalyst, of course, following by after he got access and visited the interior of the property and saw all the damage to it. That just piled it on. So, but what's unusual is if in many cases, if the tenant hadn't called the Board of Health, there are a lot of cases where the case wouldn't have happened. Because by calling the Board of Health, you might get the landlord might visit the property, and when he goes in, he finds 39 cats, or he finds terrible destruction. And so it leads to a catalyst or a reason to bring a case. But it wasn't the fact that the person exercised the right that caused the landlord to bring it. It was what transpired as a result of it. So what I think should happen here is, look, there was another omission that didn't favor the plaintiff in this case. The plaintiff prevailed in this case and was approved $10,500 in use and occupancy was due and owing, which the judge said earlier on that he would allow in the event that the landlord prevailed. That was also, in my view, an omission. This is a summary process case. These are supposed to be efficient, cost-effective cases. So although it's alarming, I just think what needs to happen here, sort of in concert with Rule 52, instead of upending the judgment or having a whole new trial, I think that it maybe should be remanded so that the judge can, I think the judge did allow the defense. He did allow it.
Really,
he said he
though?
allowed
I mean,
it.
I'm looking at the findings of fact and rulings of law on page 12 of the record appendix, which is page 2 of the findings. And the judge wrote, although defendants raised affirmative defenses, notably a facially viable defense for retaliation, in their answer, the court does not consider such defenses, as the defendant's tenancy was terminated for cause. Then quotes Section 8A and says, because the plaintiff terminated the defendant's tenancy for cause, affirmative defenses are not available to the defendants in this case. I'm having a lot of trouble squaring that with the notion that he considered and rejected a retaliation defense.
I'm no one to read someone else's mind, but I think what happened.
You don't have to. You can read his order.
Well, his order, he was thinking 8A when he wrote that order, and he's right. If this were a 239-8A case, if this were a 239-8A case, he's right. And he was thinking it was. And maybe he was thinking it was because of the use and occupancy of 10.5 was mentioned. I don't know why. But he for some reason, obviously, somebody forgot that under 2A, it was allowed and it was litigated. And the omission is, he said, yes, under 8A it's not allowed, et cetera, and he's right. But for some reason, he stopped there. And he didn't go on to say, but as happened in the trial and as I ruled in the trial, under 2A, the defense is allowed and I had allowed it. And he didn't say that. So that's why I say perhaps to clean it up, it could be remanded so that his conclusions of law could be amended pursuant to Rule 52. Instead of this is summary process, instead of redoing the whole trial, because...
Are the tenants still there?
They're still there. They are still there.
And they're not asking here for a new trial. They're asking us either to affirm or to remand for further findings and conclusions. I don't understand them to be seeking a new trial.
Yeah, I sort of, maybe that was what I heard. If they're asking that 2A, if they're asking pursuant to 239-2A their defense be considered, I think it was. I think it was not referred to in the judgment and perhaps should have been, so that all the parties could rest assured that it was heard and as everyone thought it would be and as the judge allowed it. For everyone's comfort of mind, if the case is remanded without the judgment being upended from the plaintiff's point of view, because we feel that, of course, it's up to the judge. Again, those are the facts. It's up to the judge to apply the law to the facts. If the judge concludes after having heard everything that this landlord said in that regard, that somehow that this was retaliatory and based solely on the fact that she called the Board of Health. I disagree, but it's up to the judge. But I think that, to rest everyone's minds, if the case were remanded so that he addressed it, because he wasn't wrong. He did allow the defense under 2A. He wasn't wrong. He just didn't refer to it in the judgment, is what happened. And if he wants to take further testimony for whatever reason on this point, then that's fine too. But again, I don't see the use of asking a question of a tenant, of a landlord, would you have taken this action had she not called the Board of Health? He would think that's a stupid question. He'd say, well, she never called the Board of Health. I never would have gone out there. I never would have had to get access. I never would have seen that the place was dirty, had, all the 5 things that we proved that were wrong with this place. He never would have seen it. There wouldn't have been a case. So it's almost an absurd question for me to ask.
Well, probably no need to reopen the evidence, but perhaps remand for findings and conclusions based on the evidence that was submitted.
Perhaps. I don't want to repeat myself,
Sure.
as I sometimes do, but maybe I've made my point.
Well, seeing no further questions, if you have no further argument, then thank you both for your briefs and arguments, and we'll take it under advisement.
Thank your honors.
Thank you. All right, our next case will be 23P711, Peter M. Leo versus Norman E. Leo. All right, Mr. Leo, whenever you're ready.
Okay. Good morning, members of the panel. May it please the court, my name is Norman E. Leo, pro se appellant in this matter. I am before you today regarding the discrepancy of how the property in question was held. I believe my mother's full intent was joint tenants, and I will endeavor to prove the same. First and foremost, in my continued interest of being transparent and truthful, I feel it is imperative for me to address this immediately, as I value my dignity and integrity, and it is a respect issue for me and to this court. There were alleged false accusations posed against me by both attorneys Banal and Tamori, and I take this very seriously. I admit this behavior existed by my wife. I stated that in my briefs. But both Attorney Banal and Tamori continuously began blaming me by defaming my character and creating a theme against me when I never, ever was disrespectful or contemptuous or threatening to anyone with regard to this matter in any size, shape, or form. They use this behavior to wrongfully accuse me and to advance their plan to find in Peter's favor. At the end of the day, this is like a trauma. I was blindsided. It was a lot to bear every day. This case, from my perspective, largely rests on 1, Mass General Laws, Chapter 184, Section 7. 2, Statute 1785, Chapter 62, and Section 4. And 3, case law, Philae versus Scalia, 103, Mass Appeals Court, 11/22, year 2024. And 4, case law, Ogilvy versus Idaho Bank and Trust Company. Your Honors, the deed has a discrepancy as to how the property is held, stating percentages to my mother, Peter, and I, and as joint tenants. I will state 50% each to Peter and I, and monies distributed outright the will states, 50% each to Peter and I, money's distributed outright. Exists no codicil stating otherwise. The contest provision in the will, I question whether they potentially reverse on Peter, provoking a possible violation of the will. In Article 11, Section 1101, it states, if any person, either alone or in conjunction with any other person, engages in any of the following actions, that person's right to receive any interest under my will shall be determined as, if the person predeceased me, is Peter any person just as I am, Your Honors? Paragraph 5 states, if any person files a petition or pleadings to change the character, community, separate a joint tenancy, partnership, real or personal, tangible or intangible, or property already characterized by a document. Paragraph 6, if any person claims ownership in a court proceeding to any asset I hold in joint tenancy other than as a surviving joint tenant. Your Honors, Peter is trying to claim ownership as a tenant in common, not joint tenant, as the will clearly states. It goes on to say, my personal representative is specifically authorized to defend or otherwise take action at the expense of my estate on any action that violates this section.
I'm sorry, could I ask you a question? So a minute ago you said, as the will clearly states, that you said your brother asserts that the house was held as tenants in common, but the will clearly states otherwise. Do you mean that the deed clearly states otherwise in that it refers to joint tenants?
The deed refers to joint tenants, right, and the will states 50% to be paid outright in her will. That the estate is to be divided equally. Whatever's in the estate is to be divided equally between you and your brother. Yeah. Right. So the deed says joint tenants. Yes. And it also has an allocation of different percentages, yes, which is inconsistent with joint tenancy under the common law. Do you agree with that? So there's kind of an ambiguity? I don't agree with that. I think in this case we have to look at surrounding circumstances. In this case is a will. And we clearly shows the intent of my mother when she made that deed and when she made this will.
Right. But her will disposes of her estate, of what she owns at the time of her passing. If she already deeded interests to you and your brother in the house, then those don't pass through her will. They're already yours. Is that your understanding? It's the question in the will is what happens to her 50% share.
It should go to me and my brother.
Mm-hmm.
And isn't that what the judge ruled?
Joint tenant is a right of survivorship. But what you stated with the different percentages, Your Honor, we have to look to surrounding circumstances. And there's a will here, and her intent is very clear on how she wanted her assets to go after she passed.
What she owned.
What she owned.
But in order to determine what she owned, don't we need to look at what she might have deeded to you and your brother while she was alive?
Mm-hmm. I believe that was her clear intent, as she stated at the top of the deed as joint tenants, that the survivors would take the whole. That's where I am on that, Your Honor.
And so what do you say to the cases that are cited by your brother that talk about the so-called unities of interest, or the four unities that are necessary to create a joint tenancy?
Well, I will get to that into my further on in my brief, my oral argument here, Your Honor. If I could continue. Okay, thank you. Okay, this case is named the estate of Norma Leo, which I continually disagree with, as my mother's will states joint tenants and should have avoided probate. Peter was made personal rep, then amended testamentary trustee. Where is there a trust in the will? I had a question on that. He is referred to as a personal rep, then a trustee, then a fiduciary, never a testamentary trustee. He was made a testamentary trustee so that he did not have to file a final inventory in the probate court. Final inventory was never filed and the case was closed. Helen Shiner, the realtor in the beginning, discussed with me that the house is joint tenants, 50-50, but I see it is in court. You should get 25% day of the closing, and the other 50% determined later. I go on to say, Helen never provides me with financial pages to the P&Ss, breaching her fiduciary duty and denying me my legal rights. The P&S also had two errors in it, a $6,000 error and a $20,000 error. I asked her to fix the $6,000 error and provide me with the financial pages. She fixed the $6,000 error and didn't give me the financial pages. I believe Helen Shiner, as a licensed broker, violated the order by not updating me and providing me with the financial pages to the P&S. Deny me the right to view that in its entirety at the closing. The August 5th stipulation. Attorney Fennell drafting a stipulation knowingly deceiving me by not putting the header on the document, not getting that document till months later. I feel that appeared to be an intentional, deceptive legal practice. Attorney Fennell, pretrial memorandum, agreed facts, stated below, in equal shares. Fact by me was not agreed to. She hires a special master, the Judge Peterson hires a special master, I believe didn't go by the civil procedure rules of 53. The house is sold March 15th, 2023. Judge sends letters out May 15th of 2023, 2 months after the sale of the house, stating it says tenants in common. Didn't address any of my issues at the May 8th hearing, denying me my constitutional rights. Article 15, Massachusetts Declaration of Rights. The judge in her order, the special master's motion to approve accounting, states the special master's release of her duties and the matter is closed. The proceeds of the sale have all been resolved. They have not been resolved. A hearing was never held regarding the 50% in escrow.
Just so we can understand, the 50% is still being held in escrow, is that correct?
I believe it's being held by the appellee's attorney.
Okay, but in escrow? In other words, not being distributed
But I haven't
either?
had a hearing on it.
Okay. And the 25% shares of you and your brother were distributed to you?
Yes, it was, Your Honor. It was less than 25%.
Right, there were some deductions.
Okay.
And you had a motion regarding the return of an original check that you filed in this court. It wasn't quite clear to me. Did you get a check that you deposited?
I received a check after I filed an appeal.
You did or did not?
I received a check.
Okay.
The one for $128,000 and some change. After I filed an appeal, about a month later, I don't believe those monies should have been dispersed. I need to move on. The new title report has no company name on it. no signatory. I believe it's not legal in Massachusetts if you don't have it signed by a certified licensed title examiner or a lawyer to practice in the state. A reputable title company would always identify themselves. A new created deed was never entered in the record or how the property was held. This is the new deed.
Just so we understand your argument, does that affect how the property was held, whether it was held as joint tenants or tenants in common?
Are you talking about the new deed?
Yes.
Yeah, it doesn't state how it's held.
But I'm asking whether what the new deed says is relevant to or needs to be considered when we decide whether the old deed created a joint tenancy or a tenancy in common. Does the new deed kind of tell us what the old deed meant?
I believe that new deed should have been filed in the lower court when the house was sold. And it should state the new owners how this is held. Is it joint tenants, joint tenants in common, or tenants in entirety? It just says
New owners.
the interest of and that new deed is not in the record, Your Honor. I see I'm running out of time. I don't know if you'd extend me time, but just a couple more things I'd like to say.
Well, why don't you summarize the last couple points?
Okay, that new deed is, it just says in the interest of my mother's name and myself and my brother. It doesn't say how it's currently held. To conclude, Your Honors, first I thank you all for your time and patience today. It is my hope that you will find in my favor, based on the strong evidence of my mother's intent in her will, the statutes, the Mass General laws I stated, also the case law of Fillet versus Scalia, where this appeal court decided that when in doubt, would look to surrounding circumstances to reestablish the joint tenancy where the parties' intent, I repeat, intent, dictated. I'll support my argument before you. The will clearly dictates my mother's intent. Article 401 and 403, I believe it is. My mother's will states 50% each to Peter and I, and all monies to be distributed outright. There are no codicils as stated earlier. The appellee, I'm getting to this part here, the appellee attorney will argue that I broke the unities.
Mr. Leo, we do need you to wind up, so why don't you make your last point?
Just this last thing was to answer your one question, Your Honor. The appellee's attorney will argue that I broke the unity of interest at the beginning, and when my brother locked me out, he violated the unity of possession. I thank you, Your Honor. Honors.
Thank you. Thank you, Mr. Leo. We'll consider your argument very carefully, and we'll hear from Mrs. Minchoff for Peter Leo.
Good morning, Your Honors. India Minchoff on behalf of Peter Leo in his capacity individually and as testamentary trustee of his mother's estate. So, judges, I think I would just like to point out that the lower court had a number of hearings in this case. I'm sure you're aware of the docket and the filings and the different procedure that finally, after 4 years following the passing of Miss Leo, we were finally able to sell this property, the different stipulations that were entered into by the respondent, the contestant, with respect to the selling of the property and finally getting there. But I think the focus really needs to be just simply on, we never had a joint tenancy created in the first instance. I don't even look at this as a severing. Without the 4 unities, it doesn't come into existence. And we never had the 4 unities on the deed that the appellant seems to think provided that joint tenancy. We have a judge, we have a special master that both looked at the law, made recommendations, cited case law, had a title report. The lower court judge looked at it, considered all the evidence before her, and made a decision with respect to the disposition of those proceeds.
So just with respect to the unities, you're not arguing that the appellant, Norman Leo, did anything bad or wrong to interrupt the unities?
I'm not.
Okay, so this is just based on what's in the original deed, not on any conduct by any of the parties after that?
No, I mean, could I make that argument? I mean, perhaps, but it's never been a focus, and I'm not going to make it a focus today. I don't think we get there, because we don't have to get there to start looking at conduct of one party voluntarily or not.
So we've got a deed that says joint tenants, and 184 Section 7 does talk about deeds that purport to create a joint tenancy. And then the deed also has percentages in it, percentage interest, which seems to be inconsistent with a joint tenancy. So we have two parts of the deed pointing in two different directions. What do we do with that? How do we resolve it?
Well, I think you need to go to our statutory construction, which is disfavoring joint tenancies, and understand that we're starting with a platform that says we don't want to create a joint tenancy. That's a disfavored outcome. So if you start with that and then you look at the fact, and if I may, I think that even the statute here, when we start talking about, unless a contrary intent, you only get to that statute if you have arguably the four unities to begin with, but then you have some silence of language, or you have something else that makes you question the deed. But when you don't start with, and this is why I say, I don't even think that we get to that point, because we're not starting with having the four unities, which is a prerequisite, and then you go to the statute and say, okay, maybe we have these four unities, but we have a silence of terminology as to how it should have been held, or we have terminology that says joint tenancy or some other terminology. Then you can start to look at that and do more of an inquiry. But when you don't even get to that point, respectfully, I don't believe anyways, when you have the lack of those four unities to begin with. And I think, when you couple that or backdrop against that, the fact that this was created where it used to be at common law, the joint tenancy was the default, and we got rid of that default, so to speak. That, I think, is very significant when you look at the four unities, getting rid of that default, and you put it all together in context. And there's a plethora of case law that I think supports that position.
So I'm looking at the statute, Chapter 184, Section 7, and it says, a conveyance or devise of land, well, that says to a person and his spouse. All right. In a conveyance or devise to three or more persons, which this deed was, words creating a joint tenancy shall be construed as applying to all of the grantees. That looks like it's to overrule the Fulton case. Maybe it's the beginning of the statute. A conveyance or devise of land to two or more persons shall create an estate in common and not in joint tenancy unless it is expressed in such conveyance that the grantees shall take as joint tenants. So doesn't this deed express that the three grantees, the mother and Norman Leo and Peter Leo, shall take as joint tenants?
The language there does say joint tenancy. We're not disputing that the language of the deed contains those words. What I'm trying to say to the court is, one, you can't just only look at the statute, but you have to look at the case law that's been interpreting the statute. And if you look at all the case law, and there is quite a few cases, and I cite to all of them in my brief, but even if we look at a most recent case from this court, well, actually the SJC, not this court, and that was the Weaver case. Well, the Weaver case and also the Furness v. Cerrone case, which is 493 Mass 57, which is a 2023 case, it's repeating that we don't even get to the point of a joint tenancy without the four unities. And in this particular case, it was exactly the unequal interests that didn't create the joint tenancy, which is what we have here, that missing element or prong. And so even the most recent cases from the SJC, and there was also a 2024 case out of this court, and I think that was the Weaver case, that repeated and reiterated that all of these unities need to be present for the creation of the joint tenancy. And I would say that when you have, if we had a situation where it said to Norman, to Leo, to Mom, 1/3, 1/3, 1/3 as joint tenants, and then we have in the same deed and all the other unities existed, then we need to look at this statute, and we need, or we had even the silence of it, and look at the statute and say, okay, how do we, reconcile what to do as far as a construction of the ownership to this property. But we don't have those four unities, so we don't even, we don't leapfrog over that and go to that next step.
So I just want to make sure I'm understanding this argument. Are you arguing now that the thing that destroyed the unity of interest was, I'm going to start over. It seemed to me, reading the decision from the trial court and your brief, that the position was that what destroyed the unity of interest was that separate shares were apportioned in the deed. But I think, and maybe I'm wrong, I think what I hear you saying now is that it's not the act of having apportioned it in shares, but it's that the shares were not equal?
It is both.
Okay.
It is both. So it is significant that they are not equal. And so it is both that they are separately percentage shares and that those percentage shares are not equal percentage shares. And the latter is as equally significant than the former.
So the unity of interest does not require an undifferentiated interest among the holders. It just requires that their interests, even if specified, be equal?
I'm not sure I understood the question, Judge.
I'm not
so
sure
sorry.
I did either.
Okay.
So,
it's
he'll do better.
I'll try. If the deed creates a 1/3 interest in each of the grantees, does that create a joint tenancy or tenancy in common versus a deed that grants an undivided interest in the whole?
Thank you.
So if the question is the stating of the percentages, if it just said to 1, 2, and 3 equally versus a third, a third, a third, and then it had some designation as a
No, I don't think that wasn't my question anyway. Was that your question?
I am so sorry, I'm not understanding the question.
No, that's okay. I guess the question I'm trying to ask is, I think is what Justice Sachs asked, which is, just by specifying, in other words, does the unity of interest mean you're all holding together, just like all of you together, but we're not piecing it out, whether we say in equal shares or we say a third, a third, a third, like articulating the math versus not articulating the math? That's not my question. It's articulating sort of undifferentiated ownership of the whole, right, versus differentiated but equal ownership of the whole.
So I'm going to do the best I can in answering this, and if I don't answer it directly, it's not intentionally. I think both are necessary. I think you absolutely have to have an equal interest, and that's what one of the unity prongs says, is that it is a interest, hold the same exact undivided interest. So when you have different percentages, you are now, in my estimation anyways, in my interpretation, I should say.
You're dividing.
Correct.
Right, and so that's why I was thrown when you suggested that if it had been divided, but divided equally, that it would have been okay for a joint tenancy.
Perhaps I was not as articulate as I'm now wishing I was in what I said, but that is not what I meant to convey. And I'll stop with that. Does the court have any questions of me?
Seeing none, we thank you both for your arguments.
Thank you.
And our final case for the day is 24P 449, Commonwealth versus Griswold. Mr. Zandrowski, I see we could have probably called you in the usual order today.
Right, yeah, I just was
sorry
not
to
sure.
keep you waiting all this time.
No, it's okay. Thank you for everyone's flexibility and letting me have a little bit of space.
Did you have a snack in between?
I did not, but I got some water, restroom, so I'm good. Well, so good afternoon.
Be ready.
May it please the court, I'm here on behalf of Mark Griswold, and so I just have one issue, whether Mr. Griswold would have pled guilty to OUI second, but for a now inadmissible breathalyzer test. And so I argue that in this case that breathalyzer was the crown jewel of the Commonwealth's case against Mr. Griswold. And so what really highlights this case, or what makes this case a little different, is that Mr. Griswold had a viable defense that he did not explore because of the shadowing of that breathalyzer test, that he had a pre-existing, before he was stopped, back injury. And so the back injury is moderate back and hip pain, lower back, and it was getting worse. It was a couple months before the stop, and then he went back to the emergency room after the stop for the same injury to get some x-rays about it. And so we know that, I do take some issue with the Commonwealth's argument that Mr. Griswold told the officer that he was not ill or injured, where I think it's pretty clear from what the police report says, that it says Griswold stated he was not ill or injured, but then in parentheses, back injury, but it would not affect his ability to walk in a straight line. And so I think we can fairly read that as he told the officer he had a back injury that would not affect his ability to walk in a straight line. I think that language is also important because heel to toe isn't just a straight line, it's also heel to toe. And so I think that Mr. Griswold's injury there could have played a role in his performance of that 9-step walk and turn test. I think that the other field sobriety test that he performed that day was the alphabet test, and he did nearly perfectly. He got all the way through the letters and maybe at the end said X, Y, M, Z, which I think also we could fairly say maybe the officer misheard an and.
So
there.
assume for the sake of argument that the officer misheard and as M.
Yeah.
And that the back injury might have at least cast doubt on why the defendant couldn't do the 9-step walk and turn. There's still substantial other evidence in this case, right? And why is that other evidence insufficient to form a basis for the judge's conclusion that the defendant would have made the same choice absent the breath test?
Well, I think, yes, certainly there was other evidence of intoxication. But I think it goes to, the question would be not so much sufficiency, but did that breathalyzer induce him to plead guilty? And so...
Well, I think it's got to be one of the significant factors, right? Not that it that it alone was the motivating factor.
Right. So I think in this case, essentially what I've tried to done is illustrate that there was a possible defense. And so it's not necessarily, would he have won at trial? was the evidence substantial? They had some evidence, but basically, would Mr. Griswold have taken that chance at trial? And so I think with that breathalyzer result of a .2, that basically kind of blew any medical defense, any kind of, there wasn't at that point any real hope at trial, where I think that there was at least a defense and an arguable defense at trial, colorable, and so essentially that he didn't pursue.
Can I ask?
Go ahead.
Just a threshold question. Was the motion judge the same as the plea judge here? I couldn't tell who the plea judge was from the
I don't believe.
scrawled. The scrawled signatures looked actually different. I see the assistant DA nodding. Well, you can answer that when you stand up, but.
I don't think so, but I can defer.
Okay.
To
And then,
my sister.
so the judge didn't have to credit the defendant's affidavit on the motion for new trial, right?
Correct.
Is there any need for an evidentiary hearing here? I see that it didn't appear that the motion requested one, and.
No, he did not.
Is there anything that an evidentiary hearing would resolve that's important for determining whether the, assuming we're applying the Hallinan test rather than the sufficiency test, does the judge need to take evidence before doing that?
I mean, I think we can probably find in favor of Mr. Griswold on this, on the facts here, but.
Which is what the court did in Hallinan.
Right.
There was no, right.
So I don't think there is a need for one.
But what if we were, just hypothetically, and we haven't discussed it, say, leaning against you on the application of the Hallinan test? Do you think there's anything that an evidentiary hearing could add that would make the case stronger?
I think it would be interesting to at least bring in trial counsel and explore some of these, because how far in the past this case took, and so. But
trial counsel clearly looked at the police, or she said she looked at the police report. She had all the evidence or the facts alleged there available to her, and yet her affidavit was not as strong for the defendant as the affidavit in Hallinan, which said I wouldn't have gone to trial, or I would have advised my client not to go to trial if I'd known the breathalyzer test was inadmissible. So what do we do with that? I mean, this isn't as strong a case as Hallinan in that respect.
Right, that was a phenomenal affidavit in Hallinan. But I think there was an unpublished decision here, Schnupp, where this court did essentially not, it was an absence of an affidavit altogether from trial counsel, where there just wasn't an affidavit there, and the court essentially said something to the extent of, we're not going to hold this against the defendant because it was the Commonwealth's misconduct and it's been 7 years. So I don't really think that anybody, Mr. Griswold, defense counsel, nobody was really thinking this case was ever going to come back after he pled out, and so only with this late discovery years later are we even here. So I think that plays into that.
How do you compare the facts in this case in terms of, the red glassy eyes, smelled like alcohol, couldn't perform the field sobriety test, although I do take your point about the alphabet test. I think that's a plausible explanation for why, X, M, Y, M, Z.
Yeah, right.
And in Hallinan, she admitted to 3 drinks. Here, your client admits to 2. And there is a stronger attorney affidavit. But factually, it does seem somewhat analogous to Hallinan. Is that your argument in terms of the?
Yeah, roughly.
There's a witness saying that they see your client falling off the motorcycle, and there's some,
right.
observation of.
Yeah.
Guilty.
And Hallinan was a roadside checkpoint.
Checkpoint.
But I think roughly is analogous to Hallinan. With there was some evidence that there was that defendant in Hallinan was intoxicated with the glassy eyes, and specifically the kind of the cognitive performance on that field sobriety test that just wasn't as present in Griswold. So.
One difference between this case and Hallinan, it seems to me, is that here the defendant arguably got a good deal compared to Hallinan, where the court said no, there was no special deal. I mean, the defendant here got quite a lenient sentence on the OUI, dismissal of the other charge. How does that weigh?
Well, I think he still ended up he ended up not taking that case to trial, and he still had consequences from that conviction, where I think he right now is looking at taking that chance at trial versus being convicted or not, where he had this conviction caused him a lot of difficulty. And so I think that it goes to the OUI second, and so I think that he would have taken his chances at trial, even though the deal was more favorable than Hallinan still. So I think that's the extent of what I have. If there are no further questions, I'm happy to rest on my brief.
All right, seeing none, thank you for your argument, and we'll hear from the Commonwealth.
Good morning, Your Honors. May it please the Court. Rosella Nil-Corey for the Commonwealth. Before I jump into my argument, I actually want to apologize to you and to Attorney Zandrowski for being distracting during his argument, especially because, as it turns out, I think I misheard Your Honor's question. The same judge heard the first motion for new trial and the second motion for new trial. He was not the judge on the plea. I am 99% certain.
Thank you.
So I apologize for that.
No problem.
In this case, it's the Commonwealth's assertion that the motion judge did act within his discretion in denying the defendant's motion for new trial. The record indicates that the judge was aware of the appropriate standard and the facts surrounding the case and evaluated all of them in reaching his decision, both in the initial motion for new trial and this one. The decisions, frankly, were close to identical. We have the transcript from the first hearing. The judge articulates the standard that will be applied after Hallinan, even before Hallinan has been decided, and says, I'm basically just looking for whether the Commonwealth's case would be overwhelming, whether the defendant would not have chosen to plead had this breath test not been in evidence. And while I do agree that breath test results of a 0.2 are very strong evidence for the Commonwealth, I think just as strong is evidence that an individual had difficulty even remembering sort of that he had handed his license to the officer already after giving him his registration saying, I'm sorry, I can't find my license, had issues during booking, not just displaying anger, but in making threats against the arresting officer to that very arresting officer who had been in his presence the entire time.
In Hallinan, though, didn't the defendant there also, quote unquote, seem dazed and did not appear to notice the trooper?
I would say that seeming dazed and not appearing to notice somebody are very different from a prolonged interaction with a police officer that ends in your arrest, and then during booking, you forget that that officer who is the one who arrested you is the arresting officer and are talking about the arresting officer as if they're a completely different person. I think it's a much longer interaction, and I think I can't think of better words, I'm sorry, more in-depth interaction, the nature of the interaction, because this was not, appearing not to notice him, it was conversation and on more than one interaction, making these statements about, what a mistake the arresting officer had made. And I do think that's pretty significant. I have not come across many OUI cases in which it appeared that an individual forgot who they were speaking to through the duration of their interaction.
May I just get clarification on a point you just made? I thought I heard you say that the ruling denying the first motion to withdraw his admission applied the proper standard. I'm looking at Supplemental Record Appendix 7, which I think is that ruling, and what the judge says is, after hearing a careful review of all submissions, the court denies defendant's motion to withdraw plea or admission. So where is there some indication that the judge correctly anticipated Hallinan and applied that standard?
If you look at page 41 of the Supplemental Record Appendix through page 51, that's the transcript from the hearing on that first motion, and you can hear through conversation with the Commonwealth and with the defendant's first post-conviction counsel that the judge is articulating essentially what is the standard for Hallinan. I will admit that the motion judge is fairly brief in his decisions on motions for new trial. So in that regard, it is, I would never compare it to being tantamount to findings of fact and law, but I do think.
But you're referring to where he says, that's where I'm going on this. Is there overwhelming evidence in the totality of what happened here? And that's the reason why your guy pled guilty. I don't know, I'll figure that part out.
Yes, essentially. I believe that's page 49 of the transcript, and then also I think on page 49 of the supplemental record appendix, and also I think pages 50 to 51.
That was 50 to 51, actually, but you're right, it is 48 to 49 also.
Where he discusses that. So I think he was aware of the standards, even a little bit ahead of the curve on the standards, and he applied them appropriately. The facts didn't change between the first motion for new trial and this motion for new trial. The only thing that changed was that we now had clear instruction from the SJC that the first prong of the Scott-Ferrara test was fulfilled. And as you can see from that transcript, that is essentially how it was treated the first time around.
Were the affidavits in before the judge the first time?
I don't believe so, no.
So isn't that a fact that changes, where the defendant is now coming forward with some evidence of what he argues is a substantial ground of defense?
It's something that the judge is allowed to consider. It's not something he's required to credit or...
Sure, but he's got to consider it. And when the judge at the first hearing says, the question before me is whether the Commonwealth's evidence was overwhelming,
yes,
it doesn't appear that he's considered what the defendant is now asserting to be a substantial ground of defense.
I would say that that is right. I would point out that in plea counsel's affidavit, she makes no reference to the medical issue as a possible grounds of defense, even based on her review of the file. So I do think that the judge is allowed to look at sort of that silence on that point and draw his own conclusions. I think also he is allowed to look at the lack of an affidavit from first post-conviction counsel, I'm sorry, apparently I'm not good in the afternoon, and look at that as a silence on an expected source of information, especially where the defendant's affidavit says that, you know, he never asked me about the medical issues, and why those weren't explored. So those are all, so yes, the affidavits are new to this iteration of the defendant's post-conviction challenges. But that being said, I do think there are a lot of mitigating factors, balancing factors to the strength of those affidavits.
So you obviously think we can affirm without a need for an evidentiary hearing.
Yes.
But if we were inclined to say, reading Hallinan and looking at the facts of this case, there might be a reasonable probability here that he wouldn't have pleaded guilty. If we were inclined that way, do you think an evidentiary hearing would clean things up, or clear things up, sorry?
Potentially. Testimony is always, tends to be a little bit more straightforward and substantive than
Is there anything specific on which you think an evidentiary hearing would clear things up? Any relevant factors under Hallinan?
I think potentially it could clarify to a greater degree plea counsel's state of mind during the process. I will say that unlike Hallinan, this case was resolved over a 10-month period as opposed to a 2-month period. So I do think that's another issue for consideration.
In what way?
So part of the lower court's decision in Hallinan did focus on the fact that this was a very quick turnaround for the plea agreement. And as opposed to in our case where, again, there was a 10-month stretch of time before the defendant made a plea. And so to the extent that defense counsel in Hallinan might not have had the time to sit down and look at something, for example, like a medical defense, there was more time here for interactions between the defendant and his counsel. There were multiple opportunities for her to review the police report and any discrepancies or shortcomings therein. So I do think that that is another way in which this case, although it has some facial similarities, is different from Hallinan.
Although Would you agree that faced with the breathalyzer result, the defense counsel, plea counsel might be deterred from exploring other possibilities?
Especially at point 2.
Yes, especially at point 2, definitely I think would have I'm sorry, I can't think of another word, a sobering effect on the decision whether or not to go to trial. But I do also think that the amount of time does afford a very thorough examination of all the circumstances. And honestly, the conversation about what the breath test means can possibly take place more than once, based on conversations with the prosecutor and the advice that defense counsel ultimately ends up giving is the result of, as I said, a much more sort of measured evaluation of the case than possibly was in Hallinan.
So what do you think are the one or two factors that most distinguish this from Hallinan, where the court, without an evidentiary hearing having been held, ordered the motion allowed?
I think the biggest one, just off the top of my head, is the fact that in this case, Officer Burchell was responding to a report of a motorcycle accident, as opposed to in Hallinan, where it was a roadblock. I think that's fairly significant. It sort of sets the frame for the entire interaction and what followed. And I think the second most distinguishing factor probably is the difference in detail in plea counsel's affidavit here versus sort of the level of certainty that was in Hallinan's counsel's affidavit saying this was the reason we didn't go to trial. And unless there are any further questions?
Seeing no further questions, we thank you for your argument, and we'll take it under advisement.
Thank you, Your Honors.
And that concludes our session today. I'd like to thank our court officers, our law clerks, and the court staff for their assistance. And with that, we are adjourned.
All rise.